Ah, fantastic. There we go. I see the numbers increasing. Good morning. Good morning, you fine folk of this architectural profession of ours. Welcome to our Friday webinar session. I see the numbers are coming in. There's 363. People are walking in and coming into the room. My name is Litabisa Shongwe, and I'm welcoming you this morning to the South African Council of the Architectural Profession. Today is our webinar on the infamous big monster, horrific monster called risk work. So I just want to say thank you for joining us. I know you decided to take a Friday session, Friday to come and sit here, but I think we have, we have a big task to handle. And this is not a small thing, but I'm glad that you're all coming through. The numbers are increasing. I'm not alone today. I have some of our regular SACAP colleagues that you will see from time to time. We also have an RP with us. And I would like to just give welcome to our President Charles Nduku. He's also a practicing architect. President Nduku is also a qualified urban designer. And he also sits on the professional fees committee that I chair on. So I appreciate his presence there because he also brings great expertise. Mr. Charles Nduku, President, please do take the floor as our colleagues are coming in. We are now at number 427. Mr. Monetsi, how many people are we going to be seeing today? Because these numbers are still increasing in a lovely manner.
Yes. So far, who registered as of now is 966.
966. That's spectacular.
966 are the ones that registered. Yeah.
Okay, 966. You know what?
Yes.
What I'm gonna do, colleagues, is that let's try and await all the applicants to come into the door. I can see the numbers are increasing. We're at 436 now. The numbers are coming in just before President Nduku can address us. So if you can all just give us a couple of seconds. This is that part where you'd hear that elevator music. That music that plays in the lobby. Yeah. Okay, I see the numbers are still increasing. I think when we get to 500, we'll just get on with the work of the day. There's already a question coming in. And there's some good mornings. Michelle is saying good morning. Hein is saying, JH Hein is saying good morning. And there's Darren, good morning to you too. Yes, this is a CPD webinar, so there will be CPD points. Okay, so the numbers are still increasing and the participants are coming in, but we will officially go ahead when we reach a certain number. And there's Isabella. Hello, Isabella. Good morning to you too. Thank you for joining us.
Thank you so much.
Okay, so far we have 487 numbers coming in. I think when we get to 500, I think we're just going to get on with the business of the day. We shouldn't wait. I'm sure there's a lot of things that we want to thrash out as the colleagues. Good morning, Werner and Jacobus. Good morning. Good morning, Lakram. Yay, Ray, Mr. Ray Ramlal. Good morning to you too. We have Anel Marie. Good morning, and DK Govender. There's an anonymous there, and there's Gregory, and there's Razina. Good morning. Yes, this is a CPD session, and there will be a CPD certificate. Okay, my lovely President, I think now we're at 500. Let's not keep our people waiting. I am happy that the number is at least at 500. So President Charles, please do greet your constituents, and let's get on with the work for the day.
Thank you very much, Vice President. Thank you very much, colleagues. My name is Charles Ndugu. I am the current president of SACEP. It is a pleasure and honor to be welcoming you in today's webinar. Today's webinar is touching quite a serious issue with regards to our remuneration as the professionals. The issue of risk work, and we will also be touching the abortive work. They are all related to the way that we are remunerated as professionals. We've been approached or been in communication with quite a number of professionals as early as last year, before we were inaugurated or appointed to the 6th term council. And these professionals have been discussing the issue of risk work, their concerns, and what they would like to propose to the profession as a whole. So we decided to actually host this webinar to give a platform for these professionals and also everyone who is affected, who, even if you did not consult us or talk to us or SACEP, but we all know that this is affecting all the professionals, you know, across the categories. So we have been in discussions with Manus Hennes. He is representing a group of architects who have been in discussion or talking about this topic, you know, through emails, phone calls, and then we actually made a commitment that we will definitely open up a webinar for this to be discussed, you know, by the profession, and we are here today facilitating that discussion. He has a presentation and a position and a proposal to table on the floor for discussions. So he is going to be talking to us with regards to the concerns and probably the proposal going forward. After that, we will be getting a presentation from Vusi Philane on the risk work, that is sorry, abortive work, that is also linked to the remuneration. Vusi is a current council, you know, but working for the government, and there is a lot of abortive work issues that have created lots of problems between the RPs and also the government, particularly when we have undertaken the work. That there is also a gray line area around that part of the work where, you know, there seemed to be a very little understanding about the issue of abortive work, and then Vusi decided to also bring this to the fore from the client's perspective, and also we'll be discussing that as well. But I am not going to discuss the issues, but Mr. Manus is the one who's going to give us a presentation, and then we will then ask questions and also discuss and maybe get to the solutions. And there will also be the legal framework presentation from SACEP's side, where we're standing with regards to this in connection with the code of conduct, that will also be presented. But yeah, the agenda is very clear, and then it's not a long agenda. We would like to give each and every one of you to actually participate, but because of the large number, we might not all get the opportunity to participate. But you can air your views in the chat box. You can email SACAP, but this is a very critical topic that has got to do with the remuneration, and everyone's suggestion, everyone's input is welcome. Thank you very much. Over to you, VP.
Thank you, President. As I can see, the colleagues are still coming in, which is lovely. They're all coming in through the door. And thank you for that introduction, President. I would just like to introduce further. Today, we also have Advocate Toto Fiduli. He is the registrar here at SACAP. And we also have Ms. Bessie Hlongwe. Ms. Bessie is also, she is a staff at SACAP. Ms. Bessie has a legal qualification. Ms. Bessie is going to be our legal mind, and she's going to help us to navigate the day, and regarding the legalities, and also to share some insight. And we have our good Mr. Munedzi. He is the one that looks after our IT and our matters of IT today. So I'm just going to start first with requesting that Marnus makes his presentation. Colleagues, Marnus he's a registered professional like ourselves, like President has said, and he's a South African architect and runs a practice. And he wrote us this this long love letter, very passionate, not rude, but to the point, and with very heavy items on there. But you'll see some of these items, they resonate a lot with you. And as an RP, when he wrote to us, and we're part of the fees committee, and the content of that letter, we knew that we needed to just take advantage of this and bring this risk work webinar, because we have been getting little commentary coming in from the RPs via email, call, but I think this letter is one of those things that said, you know what, let's attend to this matter of risk work, and let's see how we navigate the profession with it. So there's nothing too special about Marnus, but it's just the fact that he came together with some colleagues and they decided to draft this letter. So it represents a group of his friends that were sitting there buying, and I'm sure they're all pinched by this, and that's why they wrote to us. So my good colleague Marnus, please do go ahead, and you can flight your presentation. Yes.
Good morning. Can you hear me?
Yes, we can hear you.
Good morning, everybody in attendance. Good morning. Thank you very much, Mr. President Nduku, Mrs. Vice President, Ms. Shongwe. Thank you to Advocate Fiduli, and also Ms. Betty Shlongwe, for giving us the opportunity to present extracts of the letter that you referred to. Can I share my screen?
Yes, go for it, please.
Right, is that visible to everybody?
Yes, it is.
Okay.
Yes, I think you can just make it full screen. There we go.
Is that larger now?
Fantastic.
All right. Okay, well, thank you very much for everybody in attendance. I think, as the Vice President mentioned, it's a topic that's of very big importance, I think, to a lot of professional registered persons. And we've extracted a number of the most crucial points from our motion that was presented to the SACAP. and it was drafted by myself and a number of colleagues. I can positively say it's a growing number of colleagues. It is a motion against registered architectural professionals having to do work on risk. And I'm not saying choosing to, but having to. The intention of this motion is to assist and encourage registered architectural professionals to appreciate the very detrimental effects of being many times coerced into having to part with your intellectual property and the freedom that you have not to do so, without being financially or professionally penalized by those professionals who do choose to do so. As architects, we should act as business people foremost. We are in the business of architecture. We all have businesses with the purpose of creating profits. And without the appreciation of being intimidated into non-profitable scenarios, or even scenarios where we are losing money rather than making money. So to start with, we have to ask ourselves the very important question: why is doing work at or on risk? Some people prefer at risk, some people prefer on risk. Always expected, accepted, and entertained as the norm in the architectural profession in South Africa today. I've dealt with some clients who even refer to it as an industry standard, which just shows to what extent it has become expected and ingrained into our profession. Why is it that almost exclusively the first question asked by clients is, will you do work on risk? Will you undertake the work on risk? Why a professional registered person always expected to employ their own resources, pay their staff, pay their rentals, attend meetings, and sometimes in far off places? It's not always just around the corner. Sometimes they have to fly. Incur traveling and other expenses, etc., all at their own risk, when other professionals such as attorneys, doctors, accountants, etc., and most other professionals are not expected to do so. Why is it being permitted for architects, most of which are small practices, to effectively be coerced or even bullied, most often by much larger and financially more powerful, often listed and even blue chip corporations, into rendering their services at risk? The irony of this is these corporations and or developers are all highly liquid and financially solvent and financially much stronger than most professionals, and in reality very capable of paying for the architect's services, for which they demand the professional to shoulder the risk for their ventures. And then if the professional politely declines to do the work on risk, or even insist at least on an appointment, as mandated in terms of Rule 4.1 of the Code of Professional Conduct, then he or she is bluntly told that if they decline doing work on risk, that the project will simply be passed on to the next architect or professionally registered person willing to do so. Very often, after having done substantial amounts of work on risk and eventually asking for either some form of appointment or some payment, the professional later finds out that the work was passed on to another professional who is willing to work at risk and without any formal appointment, without the client even informing the professional of this decision. And that, by the way, is a contravention of Rule 3.4 of the Code of Professional Conduct. If a professional takes over work on risk that another professional is not willing to undertake on risk, and there's been work done, the professional taking over the work must obtain the authority from the originating registered professional to do so. And if there's any remuneration that needs to take place, that should be done. Now, just as a side note, with reference to the corporations that I mentioned, the paradox is that the people who are almost always insisting on professionals undertaking risk work are most often employees of these larger corporations, usually in managerial positions, who conveniently receive their salaries at the end of each month, irrespective of doing X, 2X, or half X. One cannot help but wonder how these people will react if their employers ask them to do even 1 month's work or even a day's work at risk. Or if the employer would tell the employee on payday that they will first evaluate whether the employee's work was profitable to the corporation's performance before they pay their salary. Will that employee continue working for that corporation for even 1 day longer? I doubt it. Now, going hand in hand with risk work is the very often absence of official appointments. Very often, clients require risk work to be done all the way, even up to stage 4.2, so that it can be tendered, and in so doing, to establish the client's project feasibility or viability. In many cases, professionals are even expected to also obtain local authority approval at the architect's expense prior to any form of agreement even being considered by the client. Now, this is being perpetrated by large corporations all over the country. Clause 27 of the Architectural Professions Act clearly mandates SACAP to formulate and administer a code of professional conduct, which they have done, to ensure that all, and not just some, registered persons comply with this code. But the architects who do wish to act ethically, professionally, and with integrity, as mandated under the preamble of the Professional Code of Conduct, and in accordance with its provisions, especially the provisions of clause 4.1, do so to their own detriment, given the accepted norm in the industry that architects must do work on risk and without appointments until the client has established some form of feasibility for the project. And after all of that, if the project is deemed unfeasible, or it does not materialize for whatever reason, or it simply is cancelled for whatever reason the client may deem fit, then it is too bad for the architect. In some cases, and please note, when I refer to architect, I make reference to all registered architectural professionals. I'm just mentioning it as architect from a personal perspective. In some cases, the site gets sold off with all the design work that the architect has done at risk, at a considerable financial advantage and enrichment to the owner or the developer, or due to new rights and proposals obtained on the basis of the architect's free labor, with no recourse for the architect to recoup their losses against either the client or the buyer or the new owner. And this is exactly why it suits the corporations and developers not to sign any agreements. It does not bind them in any way, shape, or form. There are no obligations. Ideally, there should exist a mechanism or procedure whereby these corporations and developers could be reported, and the way in which they appoint or not appoint professionals could be audited and investigated. In this way, many practices, especially the smaller practices who make up the bulk of the practices in the country, have lost and continue to lose millions in fees. And these practices don't have the access to the resources that larger, more established practices have, whom possess the resources to finance work at risk, which puts smaller practices at a major and unfair competitive disadvantage. So effectively, South African architects, the majority of which are small practices, have become some of the biggest interest-free project financiers through risk work practice by effectively subsidizing the venture of much larger, stronger corporations. But it's not just architects who are losing income through this practice. The country's economy as a whole suffers. Money for services rendered that was meant to circulate ultimately does not. Potential governmental income from taxes also does not materialize, and the government also gets shortchanged because money that should have changed hands did not, and the potential taxes from profits do not land in the government's coffers. There is the further negative knock-on effect of retrenchments and closures of practices, which contributes to an already high unemployment rate. Undertaking work at risk is an increasingly unsustainable practice that has a wide-reaching effect that has already determined the viability of the architectural profession, evident from the high attrition rate in the profession, and has become apparent in the increasingly deteriorating delivery of projects. Namely, it adversely affects the quality of the product that architects provide due to the financial risk and strains that this puts on their practice, with increased risk of building failures and health and safety risks. Secondly, before architects have the capabilities to successfully handle large or complex buildings, extensive transfer of skills need to take place within the safety net of an architectural practice after receiving an academic qualification. This requires at least 8 years of experience while being guided by more experienced professionals. Work at risk has effectively destroyed most practices that used to pass down years of accumulated knowledge to recent graduates. The remaining practices have been placed under financial pressures where they are no longer able to train young architects. The result is that young architects are prematurely expected to undertake and manage projects beyond their experience and capability, sometimes before they even understand the risk of the work they are undertaking. This is to the detriment of the projects and the built environment at large, particularly in the public sector, which generally do not get executed satisfactorily. Furthermore, the architect may have to face consequences of shortcomings they did not even understand that they have. And often it is these younger architects who are the most eager and willing to undertake work at risk in order to establish their newly formed practices. There is also the perception that the whole professional team works at risk on the new project, and hence why should architects be treated differently? This is a gross misconception, as architects' input can easily be up to 80% or more of the work at risk required. While the rest of the team contributes hours or days, the architect contributes weeks or even months, if not years. And the architect is the one that is most at risk out of all the professionals. In conclusion, it is our predicament, it's our prediction that this issue is not sufficiently and expediently addressed and resolved. The architectural profession will fall into a state of disrepute and disillusion, and we need to ask ourselves, why is it termed work on risk? Upon whom does the risk ultimately devolve? Who actually bears the brunt for all the negative effects associated with the risks? Not the client. And lastly, why is a small practice shouldering the risk for large corporations and developers who can simply walk away from all obligations, since in most instances there is no agreement in place? In a practice consisting of 1 or 2 people, if 4 or even 5 out of 5 potential clients require architects to do on risk, which has become the current expected norm, how will professionals be able to keep their doors open? And how can the profession hope to survive, let alone transform? I thank you very much. That's concludes my presentation. Thank you, VP.
Yes, thanks. Thank you, Manus. Thank you so much for that. So that's that long letter that Manus wrote that touches on several points that are disenfranchising the profession. And when it comes down to it, the risk ends up falling back onto the professional. President, I don't have the agenda here in front of me. Can you kindly just help to orbit me back to it in what is next?
All right, now, thank you, VP. Yes, I think we will hand over to Basi now to just give us a legal framework presentation and related to the code of conduct, and then we'll discuss after that. We just want to start with Basi. Ms. Longwe, can you give us your presentation, and then we will discuss this portion of the webinar.
Good morning to you all. Thank you so much for this opportunity to present. My name is Bessie, my surname is Hlophe, and I'll be presenting on work on risk. I will take you through professionals doing work at risk, the SACEP Code of Conduct, the protection of intellectual property. Thank you.
Ms. Bessie,
Yes, Madam Vice.
yes, before you jump in, can you give a brief description of your role at SACEP? Yes, your role at SACEP, your position, and how do you help the organization?
Thank you greatly, Madam Vice. I work as a legal and compliance officer at SACEP. I am also part of the investigation team. Our work is mainly receiving complaints of improper conduct from members of the public, investigating those complaints, and then referring those complaints to the investigation committee. We also assist with legal advice in relation to architectural work. We also help with amicable resolution of disputes before a formal complaint is lodged. And then we also assist with referring the matters for disciplinary tribunals and all administrative work in relation to the legal department at SACEP. Thank you.
Thank you so much, ma'am. Okay, no, go right ahead, Ms. Bessie.
If I may just ask, are you able to see the screen?
Yeah, well, yes, you can just put on that full screen thing icon on your right.
Let me try to do that.
Yes. That one on the right.
Um,
Most right. There, yes.
Great. I just want to
Oh, no. It's
show
actually
myself.
that little one.
Sorry.
The one next to the minus.
Take it to the presentation mode, yeah.
Yes.
At the
presentation.
bottom, yeah. You should be able to.
Then it just zooms it in a bit more.
Okay, let me see. Is it better?
You see a
Okay,
little
let
bit.
me get assistance. I'll pause video a bit.
Very far. We can't see it, Bessie.
There we go. Yes, I think we can see you now. Yes, we can see the full screen now. Can you see it, Chris?
Yes, it's sitting in the corner, but if everyone can see it, that's fine. Let's go
It's
ahead.
visible.
Okay.
Yeah.
All right, go for it, Miss Bessie. There we go.
You are muted, Bessie.
Just a second, Mr. Pailani. Sorry to all.
Okay. Okay, while we're having Miss Bessie in preparation, after she has given her presentation, we're going to open it to the floor where the colleagues are going to, you're going to talk about some of what you have encountered, give suggestions. Please do feel at ease. This session was created for yourselves because at the end of the day, we want to do something about this as a SACEP, but it's important that we hear the voices of the RPs in order to guide us in the professional fees committee, when it comes to gazetting. So your voices are very important, and also some of your own solutions that you have maybe employed in your practice, or what you may have learned that has made things a bit simpler. We need to win. We need to win, colleagues. So this is what the session is all about. Ms. Bessie, are you good now?
Yes, thank you so much for your patience and sorry for that disturbance.
No, it's okay.
I will be taking you all through professionals doing work at risk, the Code of Professional Conduct, and the protection of intellectual property. Working at risk effectively defers payment of architectural professionals after they have completed their contractual obligations. Addendum defines working at risk as performing work on behalf of a client, and the payment of the fee for such work is then deferred until a specific event occurs, either partially or in full. The payment of fees is a condition on the project being a success. If success is not achieved, often by an agreed date, the client has no further liability or obligation to pay the deferred fee.
If you're talking to the pages, can you talk to them, please?
I am trying to just move the page. It's giving me a bit of difficulty.
Giving a difficulty.
Mm.
Okay, well, if it's giving you a difficulty, you can continue speaking. I would have liked to see the writing on the
Yes.
wall.
Okay, let me just get assistance.
Okay. Okay, we see it. Madam Legal, we can see your screen.
Thank you, Madam Chair. I'll go back again. In the next page. I just want to go back one more page so
Okay,
that we start afresh.
yeah. Well, one can't be too surprised. Miss Bessie is more legal. They deal with the black and white. The moment they have like colors, it starts to get a bit complex. Well, in case, yeah.
Okay.
Yes.
Can you still
Okay,
see?
Yes, we see. Don't
Okay.
worry about it. Just I think we are listening, so it's more important that we hear what you have to say. Don't worry about the presentation if it's
Thank you so much to you all, and thank you, Madam Vice. Working at risk effectively defers payments of architectural professionals after they have completed their contractual obligations. Addendum defines working at risk as performing work on behalf of a client, and the payment of the fee for such work is deferred, either partially or in full, until a specific agreed event occurs. Payment of fees is conditional on the project being a success. If success is not achieved, often by an agreed date, the client has no further liability or obligation to pay the deferred fee. Work at risk requires architectural professionals to provide their time and professional skills at work. Addendum argues that professionals in the built environment are forced to work at risk. The expectation is that professionals must put their intellectual property and time at risk. Work at risk means that the fees are effectively deferred to a later date when the project becomes a success. Work at risk has no clearly defined remuneration model for professionals. Work on risk requires professionals to perform work and receive remuneration in the long run based on the case of the possibility of the actual project continuing. Often clients use the work done on risk to some extent, but no payment is made in the long run, even though the client has found some form of personal enrichment. Professionals are therefore incurring a substantial loss of potential turnover due to work completed at risk, of never continuing to a remuneration stage. If the project is not a success, the risk of non-payment for invested time and intellectual property is a reality. Often, when the project proceeds, the original professional is not re-employed due to serious disagreements. The client then utilizes the work done by the initial professional on the project at a much later date, leaving the professional out of pocket. The impact of working at risk on the performance of the entire project is not sustainable for the profession. We will go through the code of conduct provisions in relation to work on risk. Registered architectural professionals are expected to adhere to the code of conduct when performing architectural work. The code of conduct sets out the tone for professionals' conduct expected of professionals. Rule 4.1 of the code of conduct provides as follows. Registered persons shall ensure that before they undertake any professional work, they have entered into a written agreement with the client. And then the emphasis here is the word before they enter into any architectural work. The fees payable before they, oh, sorry for that. My assistant, sorry for that. Just a second, Madam Vice and all.
Ms. Bessie, I think don't even concern yourself with the visuals. Read through, we are listening. I think what's more important is that we hear your words. So don't worry about it. If you can read it off wherever you've written it, just go for it.
Okay, thank you all. We're just having some technical issues on my side. Sorry for that. Okay, I will go through these slot. It says registered architectural professionals are expected to adhere to the code of conduct when performing architectural work. The code of conduct sets the tone for professional conduct expected of professionals. Rule 4.1 of the code of conduct provides as follows. Registered professionals shall ensure that before they undertake any architectural work, they have entered into a written agreement with the client, which must include the fees payable for the architectural work or services, the method of fee calculation, if appropriate, and the stages at which the fees are payable. This is Rule 4.1 E of the Code of Professional Conduct. And an emphasis here is on the word before they undertake architectural work. The above-mentioned rule is very clear that before registered professionals undertake to perform any architectural work, they must enter into a written agreement with their client. Amongst other things, the agreement must stipulate fees payable, the method of calculating the fees, and the stages at which these fees are payable. Based on the above, engaging in risk work without a clear written agreement on the stages fees will be payable falls short of the provisions of Rule 4.1 of the Code of Professional Conduct. The difficulty with the work at risk is that remuneration is often based on the possibility of actual projects continuing. Sometimes the work of the project does not get to a stage of remuneration. Therefore, it is not possible for professionals doing work at risk to comply with the provisions of the Code of Conduct. The other challenge is that often when a project proceeds, the original architectural professional is not re-employed due to disagreements or conflicts with their client. The client then utilizes the work done by the initial architectural professional on the project at a much later date, leaving the architectural professional out of pocket. No registered professional is allowed to utilize the drawings of another professional without first verifying that the original professional has been paid fees in full. Rule 3.4 of the Code of Conduct provides that registered persons shall not use the architectural work prepared by another registered professional without written authority from the originating registered professional. This is a very important rule in relation to risk work. This is useful to all architectural professionals who performed work at risk and then get terminated from the project when it commences. If an architectural professional has performed work on risk and invested time and professional skill without any remuneration, and the client terminates the mandate when the project is a success, any architectural professional brought onto the project to continue with the project must seek the written authority of the initial professional. Work at risk requires architectural professionals to put their intellectual property at risk. It is an important part of the written agreement emphasized by Rule 4.1 that parties agree that if work on risk does not proceed, copyright on the drawings remains the property of the architectural professional. The drawing shall not be used unless the architectural professional is paid in full for the work at risk. Thank you all for this opportunity. We apologize again for all technical difficulties, and then I will take any questions if there are. Thank you so much, Madam Vice, for the opportunity.
Yes, thanks, Ms. Bessie. Don't worry about those technical things. It is a Friday. We can all be a bit more relaxed. Colleagues, you have heard the notes of Ms. Bessie. I'd like to also hear if there are any questions or even comments on this. But also maybe it's time that you can also start sharing some of your experiences or some of your solutions. It's okay to get passionate, but at the same time, let's all just be respectful. At the end of the day, just remember that it's not SACEP that created this risk situation that is happening in the profession. It's really the body of the professionals. We just need to find a way to solve them. So are there any hands that would like to share an item? Any hands? Mr. Monetsi, maybe you are seeing the hands on your side. I don't see any. Yes, President, you can go ahead.
Yeah, thank you, VP. Thank you very much. I'm not necessarily going to discuss the issue, but I'm just going to lead by saying to the professionals that you know, at the end of today's webinar, I think we need to have a standpoint as a profession. You know, given the presentation from Manus, given the presentation from Bessie with regards to the code of conduct, I think how do we navigate the space to make sure that we reduce the risk? We don't subject ourselves to the risk work in a manner that is going to cost us as practitioners. So I think everyone has a right to contribute and make suggestions. And how do we navigate the space? How do we go forward, you know, to try and solve this problem or mitigate the problem? For an example, you know, the legal fraternity. We all know that, you know, if you consult, you know, consultation, emails, as you're sitting, you know, and consulting with the attorney, you know, within an hour or two, you get an invoice itemized, you know, relating to the time that you've spent, relating to the email that the attorney have sent you, even a phone call, itemized to the last cent the attorney's office have used, or resources they've used to actually consult or deal with you as a client. Yeah, so basically, this is the problem for us as a profession that we need to solve ourselves. We're not going to be helped by external people. We can learn from external people. We can learn from other disciplines or fraternity. What can we take from those, you know, from the law fraternity and you know, accountants and other you know, disciplines that you know, are actually there to mitigate the risk work. But it's not for us as SACEP, it's for the profession to discuss and decide. And ours as SACEP is to regulate the space. The regulation is very clear what happens to somebody who takes over the works that have been done by another architect without letting that architect, getting permission to that from that architect, that you are actually contravening at rule number 3.4 of the Code of Conduct. So over to you, colleagues. This is your webinar, it's not SACEP's webinar. You must be in charge and discuss and come up with proposals, you know.
And we actually have some hands up.
Thank
Yes,
you.
and we actually have
Chair,
some- yes,
Chair, we do have Miriam
yes, I
Adebayo,
see them. I see all these hands.
then
Yes.
followed by Richard, it's Henley Smith, Mr. Ray, Gabriel, Kim. Yeah, in that order.
Fantastic. Yes, thank you. In fact, I see Zoom had ordered them for us. Yes, Miss Miriam, please share us your thoughts. Let's maybe try to keep them to maybe a maximum of about a minute and a half or two, just so we can have more hands and more participation. I think there's 600 voices that need to come through today. Okay, Miriam, you can take the floor. Thanks for those words, Pres. Okay, Miriam's hand is down. Richard Cook, you can go ahead. I think I've seen this name, Richard Cook. I think you
Yeah, hi.
some CPD webinars somewhere.
Yes,
Okay.
that's correct.
Yes, go
Hi,
ahead.
good morning. Thank you very much. Thank you to the panel and thank you for hosting this very sensitive topic. So it's really nice to say Kappa, handling this hot potato. Thank you for that. I just wanted to quickly say, I wrote a course on this, which I give, and I basically, we built a very successful practice doing work on risk. And what we eventually got it down to was a way to do it in a very responsible, sustainable and profitable manner. So you have to have a strategy. Work on risk doesn't mean that you just work for free. It's working under certain conditions. And they're normally exploratory, which means it's work that the market kind of requires a bit of exploration before it can find out whether the project is viable. And, that sort of first feasibility is really what we're trying to achieve. And what I try and say to people is work on risk is actually done on a calculator, not on a drawing board. You should not be doing drawings. You should not be doing designs. You should be doing feasibilities using a calculator in just general areas and a bit of marketing work that you steal from somewhere else in your portfolio. The other thing I always say to people is have a work on risk letter that outlines the conditions under which you're doing the work on risk. And in that letter, and in fact, Saya, I think, actually published one, and it's very thorough about the conditions, about other people taking over your work, who the copyright belongs with. So it really does protect you and what you're prepared to do, which is very important because you're not prepared to do a full detailed design. And then the next thing I just wanted to say is that I wanted to check with Miss Hlongwe regarding the legal aspects of whether your client architect agreement could include for the fact that you will only get paid after a certain milestone has been reached. So in her sort of unpacking of how it deals with the Code of Conduct rules, could we have in our client architect agreement a point that says, unless a certain milestone is reached, we agree to walk separate ways, or, once that milestone is reached, then yes, we do expect to be paid. And so, in other words, one of the terms of your client architect agreement are the conditions under which you will get that first payment. Does that not kind of keep our compliance with the code and section 4.1, covered? Thank you very much.
Okay, there are some points that came from Richard there, and Richard, he is saying that he has run practice over a couple of years, many years, and successfully doing risk work. And he says that risk work is also a desk and calculator activity. In fact, I've attended the CPD and And I've seen when he's done some of these Excel spreadsheets. So that's his view. That's the nice thing about today's session, is that to also bring some of your experiences and your views. And also some of you, your views can say, no, none of that, eradicate. But that is a view, and that's a point. And thanks for that, Richard. I would like to give a chance to the next speaker, Gabriel Greef. His name is very familiar. I wonder if it's
Chair.
my Harvey. Yes, Mr. Pailani.
Can we perhaps allow Ms. Hlongwe to respond on the queries
Okay.
raised
Okay.
by Mr. Cook?
Yes, that's fine. Yes, Miss Bessie. Thanks for that, Councillor Busi. Okay, Miss Bessie.
Thank you, Mr. Pailani, as well as UVP, and also to thank Mr. Cook for his submissions. My response to him is that the intention of Rule 4.1 is to protect both the professional and the client. The importance is that all professionals must comply with Rule 4.1 by having all 8 sub-rules of the rule in their terms of agreement. So it is acceptable that you can amend, not amend, include the terms that are suitable for you and the client, provided that your terms of appointment are still compliant with Rule 4.1 of the Code of Conduct. So there is no issue with you adding the clause. And obviously the terms of appointment, it has to be agreement between yourself and your client. Thank you.
Okay, thanks for that, Miss Bessie. Okay, I think then I will allow the next hand to come through. It's Mr.
Chair,
Gabriel.
can I come in before that?
Yes, go on.
Yes, no, thank you very much. So I think just to expand on what Bessie is saying. So if you look at this particular clause that that talks to fees payable, the method of fee calculation, and the stages at which these fees must be payable, that becomes very critical when you are then doing work at risk. So it means that you'd have to agree with the client that the fees will be payable at these stages. If you want to defer some part of the fees, then you'll be able to stipulate in the agreement that some fees will be deferred, but some fees will be payable at a particular stage or once a particular milestone is reached. And that must find expression in the agreement itself. So indeed, you can be able to manage this work at risk by making sure that everything is in writing and you don't end up working for free. You do get some form of remuneration. Thank you, Chair.
Thank you, Advocate. I don't know if there's anybody that wishes to make commentary on that or anything. Anyone? I just see some hands. I'm even, okay. All right then. Now that's fine. Thank you, Advocate, for your submission. I think we'll take the next hand on my screen. Here is Mr. Greef.
Hi, good morning, Tabi. Good to see you again.
Is it my hobby? This is my hobby. No, listen, Mr. Greef, I'm just going to say it's lovely to see you. Harvey is an ex-employee of mine 1,000 years ago, and he became my mentor, and then we ended up being colleagues on a project. But I'm glad he's also an RP. But I'm glad that you're here today and that you're giving commentary.
Yes.
Thank you.
Good. Yeah, thank you for the opportunity. So, yes, I also want to say that we've had some very bad experience with working on risk, and not because we don't have an agreement in place, but because the developers often defer the goalposts. They keep them, so we're almost there. And then sometimes the almost there can take up to 3 years. So I think we have to be strong dealing with this, and we need a mechanism where we can, with the help of the SACAP, say to them, this is as far as we go. And also what I wanted to point out is that in the early years, I was told that developers and young MBAs, they go to business school, and at business school, they are taught to use OPMs. and OPM stands for other people's money. And unfortunately, in this process, architects have become the other people's money, which they use so that they can study their ventures and see if it is feasible by using OPM. So I think the problem is really wide. It is not just opportunistic. It is actually being taught at business school. So I just wanted to contribute that.
Thanks for that submission, Mr. Greef. I have also heard this item, this OPM. In fact, there was also a course provided by some university, you know, when you're looking around. And in that developer course, it also talks about that, it actually explicitly talks about this OPM thing, and that, in fact, they highlight the fact that the architect is they're going to be your best friend, meaning they are going to be that tool in your pocket in order to realize this project. And they still keep talking about other people's money. So in that instance, then the architect's money is the architect's time. So that's where that OPM is. And the fact that it is now in the schools of education for these higher learning and smaller courses is actually very shocking. It means this has taken over our industry, that it has even gone into the policies and the curriculums of some schools, and it's actually very sad. Is there anybody, Mr. Advocate or Ms. Bessie, that would like to make commentary to this before we can get Mr. Ikram to come through?
Nothing from my side, Chair.
Okay, that's fine. You know, one of the things that I also have written here is this whole almost there, almost there, almost there. You know, it's this moving target that the architect is just working on. Thank you, Mr. Greef. If we can have Mr. Ray, my good friend, Mr. Ray Ramlal, please do talk to us.
Yeah, thank you, Chair. A lovely, monstrous program. I think I must compliment SACAP firstly, and appreciate that SACAP is always standing behind the professionals, and this is a very, very good working relationship. And thank you very much. I have two concerns. My first one is it looks like local authorities have opened up a can of worms where they're now saying you don't have to be registered to SACAP to submit plans, because you can also be registered to the engineering board. The local authority submission forms allow engineers without architects working on plans, and they're allowed to submit plans. So can we just chat on that? My second point, where Bessie Schlongwe has spoken about where, you know, professional fees are deferred because of delays and stuff at council. Council has a regulated time of 30 or 60 days for consideration. What can or how can Bessie advise us what we should include in our contract so that we can be better be guarded and earn a little bit of money at least? Thank you.
Ms. Bessie, would you like to comment on what Mr. Ray Ramlal is saying regarding inclusion on contracts? I will answer the matter of the engineers thereafter.
Okay, thank you, Madam Vice. In relation also to the first point, I think we would appreciate if we can get the information of those municipalities that are having these requirements that you should not be registered. Then we can also look into that. And then also in relation to the deferred fees, I believe you can include in your clause, as you are saying, there's a time period that is given in certain contracts where this will be applicable. And then in order to suit what would be suitable for you as a professional, because at the end, it also goes back to the agreement between yourself and the client. But I think maybe to protect yourselves, you can have clauses in the agreement that speak to time periods or how should the fees in relation to the delays be applicable? Thank you.
Thanks, Ms. Bessie. As you can see, when it comes to this whole horrific monster called risk work, it all comes down to agreements. But we're gonna talk even more further about these contracts as we go. When it comes to engineers and submitting plans, Mr. Ray, I think you are a very how do I say, a very dear and close colleague to SACAP, considering that you are sometimes president of the VAs that you're on. So please do bring those notes through to the registrar of which municipalities are doing such. But this thing about the engineers that are submitting plans, I think even the registrar could talk to this, is that there's a whole misguidedness that has happened there with the engineering council. For some reason, they have taken some of the IDOW and they've gone and gazetted something that allows them to be able to submit plans. So this is something that SACAP is going to attend to, and we're going to attend to it very heavily. Firstly, engineers, they don't have much space with participating in architectural. They should be looking at structure and keeping the structure up. But that is not supposed to be happening, Mr. Ray. And that will start to encroach on the beautiful relationship of the allied professions. And we know some of this is starting to happen as they are now tendering for architectural work and being appointed. So we're going to be heavy onto this. We are practitioners. We don't want any of this that is taking place. Next, I don't see any other hand that is up on the screen. Is there any hand, Mr. Monetsi? I think I'm hearing some hands popping up.
Yes, Smith. Okay.
Okay, Manus, yes, yeah. Manus, yes.
VP, thank you very much. I would just like to, in response to the comments made by Mr. Cook, just an observation. Unfortunately, I think architectural professionals are our own worst enemies. My question is just that if a corporation can pay, it's financially able to pay for a stage one work, for exploring and for feasibilities, etc., why shouldn't they pay? Are we not in business to make a profit ourselves? Why should we subsidize large corporations who obviously are in a position to pay for our fees? It just doesn't make sense to me. I'd like to use two analogies. When I go to a supermarket and I buy a tin of dog food for my dog, I cannot say to the shopkeeper, look, I'll go and feed this to my dog, and if she wags her tail and she likes it and she's happy with it, I'll come back and pay you for it. They'll probably arrest me on the point. And I think our services shouldn't be any different. The other analogy is a bit of a cliche. If the client wants an omelette, then he must obviously pay for the eggs and he must pay for it to be broken. It's just, to me, it's simple business sense. That's the only comment I have. Thank you.
Yes, Manus, I appreciate that commentary and also for the analogies. One of the things that I would also like to just bring in the pictures, this thing of work at risk has become so entrenched in the South African culture that even the banks have used that as part of their requirements. That even as far, I think we were having this discussion the other day, Manus, where you were saying that on some of the projects, you actually have to go as far as building plan approval and submission. So there you are getting the plans and going through the rigor of the municipality in order to get this thing approved for this person who hasn't even paid you a cent. I think Can you speak on that that example of that project you're working on for 8 years?
Yes.
We'll have Peter De Jager thereafter.
You want me to reply before we speak to Peter?
Yes.
All right. Yeah, so the example is that we are, as a practice, we have been working on a project on risk for 8 years, and it's not local, it's outside of Gauteng even. So during the 8 years, it was on off the whole time, and we had to incur costs, staff costs, rentals, traveling. We had to go there. We had to overnight, dealing with council, etc. And after 8 years, what had happened is a new manager to one of the facilities walked in, and we were starting to ask for some form of appointment at this stage, or at least some commitment for fees for the 8 years of work that we've been involved with. And as soon as we started asking for that, the new manager that walked in appointed another architect who, I'm not sure if they are personal friends, but the architect then took over this work.
Yes.
In fact, I think it was an architectural technologist, took over the work, and we weren't even notified of the fact. We had to learn from the mechanical engineer on the project that we had been replaced as architects. And because the client wasn't prepared to sign any agreement with us at that, or earlier, we had to just walk away from it. We lost all those fees.
Yeah, Chair, through you, Chair, we do have quite a lot of hands now.
Okay,
Probably
fantastic.
yes. Let's start with Peter, then Nick, David, Joanna, Cobus, Frola, Adolf, Sismandisa there. Yeah,
Oh,
then we stop with Tsako Kumalo.
Okay.
In that
The first
order, please.
hand- Yes, that's fine. Thanks.
Yeah, mixed. Afterwards, the next one.
Yes, the first hand that I saw up was that of Peter on my screen. Is that fine, Mr. Monetti? And then we'll have
Yes,
Nick.
it's fine. Yeah, he can come through.
Okay. Peter, I think Peter's female.
Hi.
Here we go.
Hi, everybody, and to everybody who's in attendance. It seems like a very topical topic because the attendance seems to be very large. And I'd like to say thank you to the speakers who set the difficulties out in a very nuanced way, because this really is a struggle because on the one hand, practitioners should be at liberty to dictate or to negotiate the terms under which they go undertake business and so on. And on the other hand, it is having unintended consequences for the broader community. So I think that the problem statement has been laid out quite well. I've done a lot of research into people leaving the profession and also into transformation of the profession. And the compensation issue for employees and also for employers are considerable. And we really do need to protect that in order to flourish as a profession. So I have a couple of thoughts about this. The first relates to this idea that this has become perceived in the marketplace as an industry standard. And I think that that is worrying because we are setting up a precondition for our kind of exploitation. And it's very difficult to know what other architects are up to, but also these individuals who ask for work at risk are typically, developers and things like that, are repeat offenders. So they will go and hunt around in the marketplace until they find somebody who will take on work which may even have been initiated by other people. You may not know about that. You don't have that information. So a thought would be to create a register where, first of all, to re-look at how the stages of work stages are set out in practice. We have the REBA thing, which we've adjusted here and there, but maybe we need to add in this work at risk phase as a specific kind of standard service where, as Mr. Cook suggested, the terms are carefully set out as a standard so that we're presenting an industry standard where it acknowledges that work at risk, de-risking the project for the client is part of the process, but we set the terms up much more clearly for our own protection. So if we did that and we put a register in place where we put work at risk and also pro bono work into a register, then we can celebrate work which we do for no cost or for low cost, or where the payment is deferred, because I think pro bono work similarly can actually show that the architecture profession is doing wonderful work, and we can improve the visibility of it. And then finally, I think that the role of the voluntary associations in this regard and in architectural learning sites in warning people about this upfront as they become professionals, so that they come into the market with a little bit of savvy and not so naively, because often, as colleagues have pointed out, it's the young, naive, hungry architects and architectural practitioners who are most willing to negotiate and most need the work on offer. That's me. Thank you.
Thank you, Peter. I have written your notes down here about pro bono work as a specific category. I would take that would be for maybe certain charities or something. I don't even think it's about showcasing an architect's ability as such, and then specific standards to de-risk. So that's my notes. And then we're gonna take the next hand, which is Rick. Rick, I'm going to give you about 1.5 minutes. I mean, Nick.
Hi, can you hear me?
Yes, Nick Kriakos.
Yes, that's correct. Can you hear me?
Yes, Nick.
Hi, my simple, I totally agree with the previous panelists that have also mentioned and speakers who have mentioned the fact that as architects, we are our own worst enemies. We've pretty much allowed this to take place over the last 30, 40 years. I represent a large practice. I've also been with a previous developer, a financial institution, and I can completely agree with everybody that it's all about using other people's money and taking as little risk as possible from a development perspective while using consultants. And it's not just the architects that work on risk, it's also engineers and quantity surveyors, etc. But we seem to be at the front end of it and the ones who have to drag through the process a lot more. But the one point I'd like to make, and maybe legally there's an opportunity to look at it, and that is, and while working for a financial institution, a lot of the times, because of BEE reasons and other reasons, financial institutions in development have wanted to use much smaller practices, young, maybe Black-owned practices or female-owned practices, which are still very small and very young and very new, but have the ability to do great work. Unfortunately, they cannot use them, or let me say, they choose not to use them, simply because these young practices just cannot carry work for that long. And we're talking about large commercial projects. They can't carry them for 2-3 years and produce, because it's not just producing a feasibility. It's about producing designs and documents that the developer can use to market the development and go to retailers and tenants out there to secure that before they can then move ahead and secure financing through institutions. So they look to de-risk their project as much as possible by using young professionals and all professionals on risk, as they call it. And unfortunately, some of them are not that nice and will drop architects. But my big question is, and sorry to have taken this long, is how legally, isn't that a barrier to entry when a young architect isn't able to actually compete in any way in the commercial environment, because the big practices are able to carry the commercial, the risk work, and therefore the young practices don't even get a look in. And it's a form of monopoly in a way. It almost becomes a form of monopoly. And I think that is probably one of the biggest difficulties for young architects entering the marketplace to try and make a name for themselves. They just cannot afford to carry these projects. So they resort to doing smaller projects, maybe residential projects, etc., which just slows their growth completely, and it's just a detriment to the industry. That's my point. Thank you.
Yeah. Thanks, Nick. One of the things that I've written here is that these big organizations, they go for these small practices. You know, I already just see that is anti-transformational. Sometimes they go to these people because in any case they know they're going to fail, and then you say, well, you see, we did give it to a small black practice and they failed, and it's going to give it to a big one. So I'm always very cautious about that, and I know my good colleague Ms. Mandisa is also going to comment about this anti-transformation. Mr. Monetsi, can we have the next hand? I think is it Kobus? It's popping here on my screen. I don't see the order.
Okay, yes, Joanna Corbett, then Frolis, then Sis Mandisa there, then Sako Kumalo.
Yes, thank you.
Good morning.
Thanks, Nick. Go on.
Good morning. Can you hear me?
Yes, I can hear you, Kobus.
Good morning. Yes, I've been an architect with my own company since 1994, and this has always been the problem. There is no solution unless it gets outlawed. If you do work on risk, then you lose your architectural license. That is the only way that this is going to get solved. That's my opinion. Because we've been talking about this, but there's no resolution. Go to any lawyers' firms. If they do work on risk as the norm, then they will lose their license.
No, I love that submission and that very succinct point to the point. Did you say make it be unlawful? I like that. If we all just say no, maybe perhaps we might just get paid, you know? Because the last thing is you'd be slaving there for 8 years, and then this person comes with a car that looks like a fish or could start flying, and then you realize, goodness, I should have charged this person. Thanks a lot, Kobus, for that. I've made a note about just eradicating it entirely. The next hand that is up, Mr. Monetsi. I've made a note here. Mr. Monetsi, can you, the next hand?
Yeah, David and Joanna, please come through.
Okay, thank you.
Hi, this is David.
David.
Can you hear me?
Yes, David Coach.
Yeah, that's right. Yeah, really interested in what the last three speakers had to say. And I think my contribution takes, I think what all of them, all three of the last speakers had to say, in that, I just put to everyone that SACAP would have a role to play in making it illegal for architects to provide services beyond a certain point. So the previous speaker spoke of making it completely, illegal from the get-go. But, and another speaker, I think it was Peter, who spoke about changing the client-architect agreement to somehow allow for it. Because it seems that that risk work certainly goes beyond stage one. It doesn't need to go to the end of stage two. And the second last speaker spoke of the point, developers wanting to take a marketable strategy to the market, to potential buyers. So there's a point just before the developers take it to the market where they say, okay, well, this looks good. This looks like we can take it to the market. Perhaps that's the point at which developers actually need to commit themselves. So I'm suggesting that there could be a certain point, a minimum point or a maximum point beyond which architects aren't legally allowed to provide work without compensation. I'm not sure that it should be part of, as Peter was suggesting, the client-architect agreement itself, because we should be paid for stage one as well. So that's what I've got to say.
Thank you, David. David is talking about finding a way to control this risk, because by the end of stage 2, you know what this building is going to be looking like and feeling like. That should be enough to sell. Thank you. Thanks a lot, David. I've made a note up to stage 2. And then the next name, Mr. Munetsi.
Is Joanna then Sis Mandisa there?
Okay, thank you. All right then.
Is it that perhaps Johan de Vernage?
Yes.
Yeah, exactly, Johan, yes.
Okay, thank you. Thank you for the opportunity to take part. I just want to say that, I've been in the architectural profession since the late 70s. And I have seen the tricks of all the professions, the developers and the clients. And I want to kick off with one question. I have seen, especially lately, like a lot of non-registered, non-professional people call themselves architects and get involved in designing and submitting drawings. Do we have a recourse? How can we handle that? Secondly, I am in full support of a more strict administration of the Code of Conduct, because I have had the experience where I did a lot of work and then the client moved to a big firm, and I only found out about it later. I contacted the firm and I explained to them that I've been involved and that I haven't been paid. Their response was, we're carrying on regardless.
Wow.
Now, again, I feel that there must be a mechanism that we can act against professionals acting outside the Code of Conduct. I think that's just my bit that I want to emphasize is I think we must be more strict in Code of Conduct, and we must find a way to address the people that's coming into the pressure, which is not architects, which is not registered, because it's really out there and it's happening day after day. Thank you so much.
Thanks for that, Johan. I like the fact that, I would often think that there's got to be somewhere, in fact, maybe I'm going to put this to SACEP, that we find a way to also put responsibility also back to the client, where they need to sign and confirm somewhere that I know and I have confirmed that this professional is indeed registered, or they say that this profession, I know this professional is not registered and I'm willing to live with whatever. So if we can maybe have something like that, I don't know, I'm going to put it through to SACEP because I'm very passionate about that in one of the committees. Thanks for that, for that submission, Johan. And is it time now to have my Councillor Mandisa, my colleague Mandisa, to make comments? Mr. Munetsi?
Chair, am I audible?
Yes, Councillor Mandisa. She's also a practitioner there in KZN, and she sits on our council. Yes, Ms. Mandisa.
Greetings, Chair, and all that are in attendance. Thank you for this webinar. Yeah. My comment is on what our other colleagues have said regarding working on risk. I'll make a few points for consideration. The first one is that in our work stages, there's a strong point that was made there by Richard Cook, where he said that their company has been doing work at risk, but they are very strategic about it. And he made a point that the nature of this work must be a feasibility contribution. You conceptualize the feasibility of the project to realize whether the project is feasible or not. So I think that point is very important, that we must know that you cannot go past that if it's at risk. And that takes us to the work stages of SACAP, that we've got 6 work stages. And the 4th stage have been split into 2, which is 4.1 and 4.2. We may perhaps consider having a 1.1 and 1.2, where we are able to mention that feasibility is a stage, and it can be guided what can be done on that stage before you get to actual inception. Because this talks to the emerging architects, because in this audience now, we have very experienced architects who have done and bent their fingers. And then we're at a point where we must relearn and undo so that we don't continue with this. I heard also about the OPMs that have become literature in some business schools. We need to counter such. This is an awareness webinar and educative, and also we are contributing. But also it mustn't end there. We must produce our own papers, our own articles to counter that type of narrative. Because those who are going into the business schools and come back and take advantage of us, it's because we are not putting forward our own narrative. Because I've seen, I've been in business, I'm going for 20 years this year, and I've been...
Okay,
Yes. Mr. Munetsi, you can allow Ms. Mandisa to carry on. Go on, Ms. Mandisa.
All right. Whereby I've been in business, I'm going for 20 years, and you find that practically you do certain things in business, but scholars have found ways to articulate what we've been doing because we're not on our own able to articulate. Now in this audience, there are architects that are able to articulate work on risk and what is right and what is wrong. And perhaps SACAP could take up that opportunity that those who have done this in the past, we can produce our own narrative and also regulate that. And also, I heard mostly when we spoke about emerging architects or transformation, SACAP can produce templates, like a checklist. If you are doing a risk project, what do you look at? For instance, I've done risk projects whereby a client will come with a dream to find they don't even own the land. So certain aspects of that nature, a young architect may not know what to consider when they are working at risk. And also we have a client architect agreement that exists. Perhaps we have a comprehensive architect client agreement. We have a compact one. We can perhaps consider having a work at risk agreement so that it outlines and complies with the code of conduct. So those are my contributions. Thank you, Chair.
Thanks there, my good colleague, Councillor Mandisa. I like the point that you raise about a possible a sub-stage or a co-stage in stage 1 or stage 1.1 that talks about feasibility, and this is where possibly that other suggestion and calculation of a desktop study by Mr. Cook, maybe that's where it can come in, because as architectural professionals, we do know that, and we have the acumen to be able to decipher what could be the possible building budget when you are putting together a building. If it's a certain building of a certain luxury and the square meter, you can put together using a rate or something to have an idea. And that's what saves all of this work. And I also did note what Mr. Cook said there, that sometimes you don't have to go and recreate a whole new building. Just fetch something from your portfolio and throw it at the this is that. The next person that's going to come in there, thanks, Ms. Mandisa. We have Barak.
Yeah, the next person, Chair, is Nsako Kumalo.
Oh, where is it? Okay. Yes, Nsako.
Thank you.
Yes.
Yeah, thank you for the opportunity to to share some opinions. I've been in practice since 2008. Previously, I was an associate with 2 other firms, of which both did work at risk. And I saw the many pitfalls and the many losses of business through work at risk. And since 2008, when I opened my own practice, I vowed not to do work at risk at all. And I do have to say that young practitioners need to stick to the principles. And if you stick to not doing work at risk, and if you stick to charging full fees and demanding payment on time and demanding your worth as an architect, it will pay off. I have been in practice for 14 years. I can say that I have not missed a payment from a client since then. I have not charged below the SACAP fees for any project whatsoever. I've always charged full fees, whether it's alteration and additions, new work, heritage work. And I do think that the principle needs to drilled into the young architects to stick to the SACAP rules, to stick to the fees, to refuse to do work at risk. And that is, to me, is the key for a successful practice and a happy practice. And just one last thing is that I agree with a few other colleagues that were mentioning it, that work at risk should be completely illegal and should be put into the code of conduct and into the rules of us as professionals. Thank you.
Thank you, dear colleague. I'm just going to take it back to the panel. Is there anything that any of our panel members would like to say? Councillor Vusi, even though you're working at government, you're also a professional architect and project manager, or Advocate Toto, or President.
Yeah, look, VP, thank you. Thank you to all the participants. The issue of work on risk is very sensitive. It's a thorny one, and it's very important. We take it very important, the SACAP, because we really want to transform the profession. We stand behind the profession, and it's important that we are paid for the work that we do. Risk work affects all of us. It's our livelihood. You cannot work and not be remunerated for your own intellectual property. So we as SACAP, we stand strongly against the issue on work on risk. There are some suggestions that are put, but our position has been discussed earlier by Ms. Hlongwe, and how we view and want to approach the issue on work on risk. We see it as though perhaps we can look in terms of dealing with it in terms of including certain clauses. There are some suggestions that perhaps we illegalize it, we abolish it. But really the aim of today's webinar is to allow the profession to speak freely. We want to educate you, and we want to really transform the profession. So yeah, that's my view, VP. My presentation will follow shortly. Thank you.
Thanks, my good colleague, Mr. Pailani. I think you did say well when you said today is really about our RP colleagues in sharing their topics, and I mean in sharing their concerns or their suggestions. The previous speaker has just said he made a covenant with himself and his practice 1,000 years ago that he's not going to do free work. And you know, that is a position that one can take. And you just give it up to the gods and the ancestors and your hard work, and you know you will be supplied and you'll be supplied sufficiently. So I commend him, and I know there are some colleagues that also take the same position. But let's have, is there any other hand from a comment from maybe from in fact no, let's take the next hand. Richard, your hand is next on the screen. If you can maybe talk for 30 seconds, because I
Yeah.
know maybe respond to the previous speakers, and then we'll
Yeah.
have, and I see is Adrian. Adrian.
Yeah, thanks. Thank you very much. Just very quickly, Manus asked, why should we do work on risk right at the beginning of this section? And, you know, why should people not pay us if we buy something from the shop? And the point is that every work you do, even work you do not do on risk, even work that you do commissioned, you go to the site, you meet the client, you take a brief, you have to do all that before you can actually generate a fee proposal anyway. So every single job we do in one way or another, we are doing work on risk. We are committing time and effort to actually secure the project, sell our own skills, find out what the project entails, find out what we require in order to generate a budget that is realistic and accurate so that we don't end up in trouble later. It does involve a commitment from us. We do have to go to the site. And yes, we will be paid for that. So in a way, every job we have done is work on risk to some point. So I really liked Peter's idea, and I liked the Mandisa's idea about we should reinvestigate clause 1 of the client architect agreement, work stage 1, and break it and actually identify those things. And we could write it into a very powerful client architect agreement that would protect us. And that what we could do is, there is already a letter for doing work on risk that exists. There are already conditions, and we could transfer those conditions into our client architect agreement, and it would just establish what we're committing to. And so I think that that's actually a very, very useful observation. But if you think you do not do work on risk, you are just deluding yourself. I promise you, you do work on risk. We all do. It's just the nature and extent of that work. I wrote my whole business of architecture course was written around empowering emerging architects, because like me, we went through so many, we lost so much money. We did things so badly for so long. And I did some government work, and I just saw that the way that the emerging architects were being treated, and I kind of just wrote all the crib notes. And it's like now it's about a 70,000 word document that that I've captured that. So yes, it's the younger architects who are the most vulnerable, and they really do need to be upskilled on this, and they don't need to make the mistakes that we made when we started the company that we had at the time. And that is the fact about you seriously limit what you're prepared to do, and you use lots of file stuff. And if you don't have file stuff, you create mood boards, you take photographs of other stuff, or you go on the internet and you create a mood board. What you don't do is actually do a detailed design. And if, like Manus was saying, they got hooked into a job for 8 years, there is a point where you have to parachute out of the process, where you should be getting paid. And that point has to be secured in writing in some sort of agreement, be it a client architect agreement or be it a work on risk agreement. Nick was talking about retail needs deep involvement, and that is absolutely true. If you're involved with retail, then you're in for a very long ride, and if you're a small company, I don't think you'll survive, because the way retail works, when you're trying to sign up tenants for a large project and they need you continually working, you can't do retail on risk. You have to get a client architect agreement in place, and you have to get payments. That work is actually not on risk at all. If you look at it logically, it's not on risk. And then the guys who, just say, look, they just have found a way to refuse to do work on risk. That's fantastic. Of course, we would not choose to do it if we didn't have to. You know, you can't outlaw it. You know, if SACAP say they're going to make it illegal, what they're going to do is they're going to take away an entire world of opportunity that's available to us and take it off the table. I firmly believe that if we do work on risk, we must do it in a sustainable, profitable, and responsible manner, and it can be done that way. But to outlaw it basically robs us of an opportunity to get work. We ran a very successful practice for 20 years, and it all started on work on risk. And we worked with several developers, but 3 of them for the entirety of those 20 years. We had a good working relationship. We did a lot of work on risk, but we did an enormous percentage of that work turned into projects that paid as well. So there has to be like sort of clarity and understanding of how work on risk works and what its point is, why we do it, and it can't just be dismissed and kicked off the table, because otherwise a lot of us are going to be very poor. Sorry, I went on for more than 60 seconds, I'm sure. Please forgive me.
And Sako Kumalo, you can come through. Atuse Matsika, Moses Boysen, Nadia, you can come through.
Thank you so much. Through you, Chair. Can you hear me?
Yes.
Thank you. Yeah, it's Moses here. I've been an architect for more than 30 years, and been in my own practice, for almost 19 years or so. And I would agree with the very last speaker, and I think a few others, when he said that in practice or in real life, almost every work that we do is actually on risk, I'll give you the examples. For example, you do work and you send out your fee claim, and clients, sometimes you would have agreed with them for them to pay the fee claim in 30 days or 60 days or whatever it might be. That in itself is a risk, because some of us have run into cases where, yes, we don't call it work at risk. You do the work, you invoice for it, and eventually the client doesn't pay for it. So it was still work at risk. Because if it wasn't, then I should not actually be sitting with the issue for fees or chasing my fees and so forth for work that has been done. So in short, I fully agree that architecture, the way we look at it, it is both a business and it is a practice. That's the reality of it. And even when we look at guys like people like electricians, plumbers, and so forth, many of these will never come to my house to attend to a small plumbing problem unless I pay them some money upfront. Okay, it might not be the full price, but they always ask sometimes for a call-out fee, sometimes a deposit, and so forth. All that they do it to try to manage their risks. And I think in architecture, if we accept that it is a business, not just a practice, but it is a business, then we have to accept that we are operating in a business environment. And in this business environment, if anyone can use your money or my money for them to achieve a certain milestone without paying for it, they'll do it. And that's why there's even the concept of people paying 30 days after your invoice, because they're still using your services, they're enjoying them before they pay a single cent. So I just wanted to say that we need to accept that architecture is both a business and it is a practice. Now, if it is a business, we have to learn to be shrewd, we have to minimize our risks, but everything we do, almost everything we do, there is an element of risk. And for that reason, I agree with the idea of perhaps limiting the exposure or the amount of risk that we are willing to carry on. For example, if you're looking at stage 1, we should not put ourselves in a situation where we do the entire stage at risk, but we should perhaps say we can go up to this far, beyond which the fees have to be paid, because we need money to run our practices. We need money to pay employees and so forth, you know? And that's a concept of almost anyone who runs a business. At some point, someone has to pay for it. And I think that's where we should wait. Thank you so much. That's my small contribution.
Hi. Am I audible?
Yes, you are.
Yeah.
All right. Atum Siska here. I think there's an aspect I would like to just contribute, which I think is quite an important thing. I think SECAP has done quite well with saying that PI should be mandatory. But I think also something that I think the best way to protect architects at this moment would be to ensure that your client architect agreement needs to form part of your municipal submission documents, because that removes the negotiation factor. Because I think once you've kind of made it mandatory that it needs to be followed, I mean, it's quite a thorough document. So once it's mandatory that it needs to be followed, it becomes a lot easier then to take legal action against clients who refuse to pay and all of that stuff, because you do get clients who will come to you and say, well, I'll pay you the full fees, but I don't want to sign any type of contract or whatsoever. Or people will just try to negotiate with you. And I think I'm speaking from the young architect's perspective. I've been running my practice since 2019. I'm 32 years old, and I think I've paid my school fees, and I've gone through the clients who just want work on risk. But what I've also come to learn through some advice from a lawyer friend of mine is for work on risk, he's just busy trying to help me set up the contract. But for work on risk, what he said is, you can do something similar to what's done in the JBCC, where the client cedes the site. The client doesn't have kind of legal ownership of the site until it's completed. So similar to work at risk for architects, if there could be a contract where the risk on the architect side is to do the work at no pay, but the risk on the client side is that he's also risking ownership of his property for the period of time. So that was kind of how we ran through it. So we call it kind of an equity trade proposition, where we calculate the value of the works of the architect and compare it to the value of the site. And then whatever the calculation is, we take over that portion of the site. And then the client, in essence, has to buy the land back from us, so that if we are ever in a position where the client hasn't paid, we can sell off our ownership of the site to the bank or to another individual or whatever. But that percentage which we own isn't in ownership of the client. I think we've set it up for 12 months, where if the client hasn't paid you within 12 months, then you are at liberty to basically sell your percentage of the site to either the bank or whatsoever. But what it does is that it puts the risk on both sides now, instead of the risk just being completely on the architect side.
Thank you very much. Thank you very much for that contribution. Apologies, Tsabi or VP, he has a problem with the sound. Hence, I have taken over now. But until she sorts out the sound, that I will be continuing with this. And I think now that these inputs are coming in, and I think at some stage you're going to have to wind down and probably come up with proposals. I think the proposals are there, and we are definitely taking note of these proposals that have got to do. These proposals can actually find their way to the code of conduct. And I think it is clear that at the end of the day, it is a business. I think the agreement and the engagement is between the client and the professional. And if you can use the documents that we have, our exposure code of conduct, to mitigate the risk, to reduce the risk exposure. I think it is coming across clear, in the contributions. But colleagues, I don't know, Monetsi, you probably see who still has the hands, and now we are going for 12 o'clock, and I think we should actually wind down this part of the webinar. And but before we wind down, we just need to actually come up with a way forward on this issue. And also, I know that there's lots of contributions, in the chat box, and I think SACEP is taking that into consideration. And all of these contributions will be put together, and then SACEP will actually put something together in line with what has been suggested by participants here in this webinar, and then forward it to the profession. If we probably need another workshop, or we need, but we definitely will communicate it back, and then we might end up having to come up with guidelines of doing risk work at the end. But I'll take few hands. Monetsi, I'll rely on you, and who is available to contribute. And probably,
Okay.
yes.
Yeah, we have got a few hands. Yes, Boysen come through. Boysen come through. Karabo.
Monetsi, prior to the participants perhaps coming through, there is still a small presentation on abortive work. Perhaps I conclude that presentation, and then we allow our participants to contribute, towards the risk work and abortive work aspect, if you'd allow, President.
Okay, maybe let's do that, Mr. Pailane. Let's go ahead, and then we clap everything together. We come up with the way forward. Thank you. Go ahead. You can share and talk about the abortive work. Over to you, Mr. Pailane.
Thank you, President. Is my screen visible?
Yes, it is visible.
Yeah.
Oh, okay. All right. Okay, so my name is Vusi Pailane. I'm a council member and chairperson of IDEO. I work for government, and I've had first-hand experience working on risk work, and I know very well the challenges and frustration we all face as architectural practitioners dealing with unscrupulous clients and developers. Mine looks at another aspect which relates to having to do work on risk. Okay. And okay, so my topic is really about abortive work and what is abortive work. Abortive work or abortive cost refers to work that has been done or started but is no longer required. This work will not form part of the final development and is regarded as wasted work. This work may have brought costs for the architectural practitioner, but you find that the work is no longer needed by the developer and therefore is considered abortive. And this work can occur at any stage of a project and relating to tender process, the work of consultants or construction. Okay, so when does abortive work arise? Usually due to cancellation of a project or an element, failed or abortive tendering, when the scope change of sites, change of whether a project was initially heritage and now it's changed to new gold. You've done all your heritage assessments and studies, and the client now decides to demolish the structure. And therefore, this means all the work you would have done on the initial stages is considered unnecessary or not needed by the client. And other circumstances where this arises is due to refusal of planning permission or approvals, changes in requirements, budget, location, size. We've all experienced this as professionals, or the work that's done is not authorized or not properly understood. There may be clashes in coordination between consultants, design changes in manufacturing or construction, changes required once the completed works have been seen, and when procurement of redundant goods, material, plants, or personnel. Okay. And how do we then minimize the risk of abortive work? Having a client architect contract agreement in place with clauses that clearly spell out who takes the responsibility for abortive work. You need to be thorough in your designs, in your work. This means having a thorough site investigation, conditions surveys, ensuring that the project brief is comprehensive and is supported by all stakeholders. So at brief stage, you need to ensure that all the boxes have been ticked and that you've clearly understood the brief. Ensuring that the risks are properly identified, who's going to be responsible, introducing change control procedures at certain milestones or gateways within the project. You apply for permissions early as practicable, and you ensure that the designs are properly coordinated so that you minimize any changes that may occur later. Adopting quality assurance systems. This may be difficult for emerging firms who are usually one man and no one else who checks their work. So ensuring quality assurance or that your plans are drawn according to prescripts and your local municipal bylaws. Site inspections, professional indemnity. These are some of the means you can use to minimize abortive work. And who's responsible or liable for abortive work? When it's carried out, the cost of those works will be allocated depending on the wording in the contract and the clauses. And therefore, it's imperative we clearly spell out, how and what abortive work within our contracts. The cost may be borne by the client if the conditions set out in the contract have been met, and the client must therefore take the responsibility for the risk. Okay, where a change has been instructed by the client in accordance with the contract that might result in abortive work. Okay, so this may give rise to additions or deductions to the contract sum. Where the consultant has carried out unauthorized or non-compliant work, or they have accepted the risk for unknown items, the consultant or the architectural professional may bear the risk to carry the cost of abortive work if it isn't clearly spelled out in your contract. Okay, that concludes my presentation, Press. Thank you.
President, am I audible?
Yes, are you back? Are you back, VP?
Yes, I am
Okay.
audible. I lost
Yes.
sound there. Thanks.
Okay.
And yes, and that was that's colleague Mr. Busi Pailani. He's also chairperson of IDOW committee. And he is talking about how to avoid risks on a board of work, and how also maybe to get paid on a board of work. I think maybe Mr. Palani, if you can speak a bit of your experience, seeing as you are sitting in government as a chief architect, and explain what you are seeing and why, and what makes it hard to remunerate a board of work. What are the challenges, and what do you think can be a solution? Thereafter, colleagues, we're going to go and take a good body break, and then we'll come back again with more comments from the floor. Yes.
Thank you, VP. My role as a chief architect within the department involves having to check fee compliance, fee claims for architectural practitioners. And we find that abortive work isn't clearly captured within the government bespoke contract. This means that any work that you may have done during the initial stages, it could be survey work, it could be work, most government buildings, we don't have existing plans. Work where you are measuring up or documenting an existing building needs to be clearly captured in your contract. Because if there are any scope changes, if you're doing work of heritage assessment and there's scope change, there's a site change, you should still be remunerated for the work you've done. And some contracts don't capture clearly, precisely how and the amounts you should be paid, because it seems like it's a duplication. You should be charging your fees based on the value of work, and this value of work is based on the scope of a project, whether new build, alteration, refab, or restoration. So it's important we educate our RPs on abortive work and how to minimize the risk of taking over that. It's a financial risk, and it needs to be spelled out in your contracts. Yeah, so that's my role, VP. I check fee accounts.
Yeah, so I'm gonna ask you a point, though we sit together at SECAP, but you sit on the government side. So I'm going to ask you now. Say I'm appointed and I'm working on this work, and then the client, somewhere the client says, "Oh goodness, we actually want another wing or another block of buildings. We want to add another square meter, and it must come in there. Why can't you just pay me extra? I mean, you're a chief architect. Can you tell the process what makes it hard for you in how the system is set up?
Yeah.
Why can't I get paid to go and almost readjust my stage 2, go back again and bring all these other new inclusions?
Yeah, look, there are contracts that allow for variation orders, and they simultaneously increase the contract sum. Government operates on tendered amounts, and those amounts are usually the cost of work or the value of the project. If you change the scope, if you change the sites, it's a different contract sum. And if you are claiming fees for, work you've done separately or work that's, an afterthought, it's seen as though it's a duplication. and hence it's important you have clauses that deal with scope creep, scope changes, and abortive work.
But my Councillor Wusi, you would know, no, I don't think any architect would go and just elect themselves to go and bring a whole lot of additional scope. I know sometimes we try to be a little bit, brings in some extra frills and things there, but in the main, any changes to a project is usually occasioned by the client. So what I want to know is that when those changes happen, are you as the department opening to just, oh, okay, no, this has increased this project scope by almost 30%. We're going to adjust the professional's fee. Is it a simple route, like just to do that, or was it supposed to have been embedded in some God contract somewhere?
Yeah, VP, construction projects are unique, and each project has different circumstances, and you have different officials working for government, different departments, and they don't all apply the same rule of thumb. And construction projects are unique. All I'm saying is ensure that clauses are included to protect you as a practitioner.
Okay.
I see there's a hand from President.
Yes, Pres. Is it a body break?
Just before the body break. Yeah, I think thank you for the presentation, Lucy, and I think you are giving us answers. Yeah, you are laying out the problem. I've been facing these issues, and again, it boils down to the question of addendum to the contract. If there is an instruction to add another wing, we've experienced some of these issues, then that must be reduced down to writing by the client as an instruction, and it finds itself into the contract, so that at the end of the day, you are covered. You don't lose out on the abortive work. And also, what is usually a risk in the government space is that the government representatives move around, or there is a new director now that has taken over, and now he does not know or have any proof or evidence of that instruction. But if you have a contract that has an addendum which is covering that instruction from the government, I think is usually attending to the risk that you might be facing. So basically, I want us to agree that this is the from the point of view Mr. Palana is putting from the government side, that he has put forward suggestions as to how to minimize risk abortive work, related to all of those instructions and other aspects that you have to work with. So I would propose that maybe after the body break, we allow other inputs. Participants can participate or offer solutions or suggestions to both issues, and then we move towards a winding down suggestion, closing the webinar. I agree with the body break.
Okay.
Maybe 10 minutes. Yeah, thank you.
Yes. Okay, fine folk, if we can come back at 12:30, it's enough for the body and enough for a coffee and a sandwich, or whatever is your vice on a Friday. And then please do come back so that we can hear more from the colleagues. I am deeply appreciating the committee that's coming through so far. I think we're gonna get somewhere. So we'll see you just now in about 15 minutes, 12:30. Talk soon.
Yes, no, that's fine. I'm glad we are back. I actually regret a little bit. I should have said that we should have a bit of a longer break. Now I have to have ramen noodles for lunch instead of something decent. But in any case, I'm glad that we're back. Colleagues, it's now 12:30. We're going to continue with our session. What I want to do is, before going back to the hands, I'm going to go into the chat box. In the chat box, we have some colleagues that have written in, even though they are not going to speak through, but their hands are actually quite important. Somebody says, I'm just going to read them. I didn't filter them. Thanks for this webinar. Apologies, having to leave. My view is risk work is illegal, means PI insurance would deny responsibility to cover professional risk. That is a huge risk to a client and to yourself. Yes, this is another one, professional indemnity and risk. And conversation with another colleague, what they noted is that, you know, when it comes to professional indemnity, and should there be a claim at a later phase, and you've done this work that is at risk, what you may be asked is, before that claim is covered, you would be asked, did you do everything that was meant to have been done to ensure that we don't get here? Now, if work is not being paid, it means you either will have to speed through it, or you may have to cut corners in order to make it financially feasible for you in the office. And if they found that you were lacking, or you left an item here or there, or certain checks and balances, it means that you might not be covered. And that's now another second risk that the architect is going to be facing. You'll be out of pocket for the fact that you had to fund the work and subsidize the work, and out of pocket again regarding the fallout. Okay, and then there's another comment from Ms. Nondu. Ms. Nondu Miso says, thankful for an insightful discussion. I have to agree that much guidelines are needed for risk work. As to a certain extent, risk work cannot be avoided, but it must be calculated and managed. I always say that if a bank cannot give a client money on risk for risk work, who are we to be above the bank? That's a very good point. So in the context of what we provide for any project to have a takeoff, we need to finance this work in a responsible manner of high contractual liability to the client. SACEP is certainly, we certainly need help for this. Okay, and then there's another one from Frederick Lotter. Morning, I see that there are a few queries. Yes, this is a CPD webinar point. And okay, no, that's it. That's a personal question, very personal question. Okay, and then there is another comment here from John Bizinos. Just an observation of having appraised architectural work and practices over 2 decades. Is that unethical tendencies are practiced across the board from small and very large architectural firms regarding work on risk and colossal discounts of fees of up to 75% by the latter. And if statute placed a total outlaw on work on risk, then SACEP would have to employ a bank of attorneys adjudicating such practices. A possible manner to mitigate these practices have been aired by the participants, which the scripting of the work on risk contracts appeared to be more effective. So he's talking about 75% off and all this discounting, and that's just really pathetic. That is happening in our profession. And then somebody says, if approved drawings and building plans issued by the municipalities are bound to the professional, would that give the professional further negotiating power? I.e., only the professional on the approved drawings building can permit and can facilitate the occupation certificate. That's also a very good point. What this person is saying If these are my drawings and you have not paid them, you cannot and you will not get an occupation certificate. Though the occupation certificate is something that is issued by the municipality. But this is again someone saying to find a way for you to take control over giving occupation. And then we have Mike Buller, who says, thanks for this webinar. My view, okay, now I have read that one. There's another one that I made a note down here from, okay, here's Eugene. At the end of the day, each professional has to decide how much risk they can take. It is your business and your decision. My first consultation is at risk. Terms are discussed at this meeting, after which I present my fees and conditions. I do not continue with any work unless the client has accepted the fee proposal and conditions. And that's what Eugene has to say. And there's Cornelius, who's appreciating the comments and is taking them seriously. And there was another item by Brenda, but I see she has actually deleted. Brenda was talking about, surely maybe she mentioned that, you know, she asked for a deposit and some bits of payment. Brenda, you had a very interesting point, and I actually read it. You're saying that you take a certain chunk of money as a deposit at the beginning, and then interim withdrawals from the client, small withdrawals throughout the stages, up until you get to a certain point, which I also do like that. In fact, I am a believer in that, you know, to at least be getting something at each and every single stage, not nothing, you know. Developers and business people should also have their skin in the game when it comes to this. Okay, here it is, yes. Brenda Van Schie requires that a minimum to be compensated for time and expenses as a deposit to be deducted from the final bill in the project if the project continues. I use a timekeeping app as a rule for all my projects. Pick and Pay does not let you take food home before you pay for it. Okay, Mr. Monetsi, and then I see the next hand on the screen is Adrian. So we have about an hour and a half. We are going to carry on with these comments that are coming through. We are loving them. I'm loving them. We're taking notes, and I can tell you that they matter. Adrian Kutsia.
Hi, it's actually Adriana. Yeah. I'm quite new still to the industry, so but I feel that I've already seen a lot of the bad practices in different architecture firms through.
Adriana. Okay, another thing in the industry is that you're going to need to speak boldly and loudly so that you can be heard. Okay, we want to hear what you have to say.
Voice.
Then speak into your microphone. We want to hear what you have to say.
Okay, is this better?
Far better.
Thank you. So just on the thing with risk work, I find that another component of it, and it speaks to the discounting of fees. This doesn't just happen with private corporations. This also happens in projects with our local government and our local municipalities, where yes, you have to tender for the work, but essentially the lowest price is the one that gets the tender, which means that your architectural fees are already lowered from what the standard is that's published every year. And now you have to do work at a reduced fee for a government institution. And on top of that is often the work is a lot more because we found that obviously there's a lot of buildings that don't have council plans, so there's a lot of back and forth with having to survey and do that work from scratch, and then only start design. And often the contracts are only for a certain period of time. So because there's items that might delay you getting to the next stage of a project, you might lose out on your appointment because it's exceeded the financial their financial year. So I find that it's not just holding accountable the industry professionals, the architects, the technologists, but we really need to have something that can hold accountable the clients. And whether these clients are large corporations or government institutions, yeah, it's essentially you make a loss on a lot of these projects, especially if you also have to tender against other people. And then for some government institutions, if your appointment runs out, another architect then works on your drawings, which is just accepted. And often if you take over a project, that architect did the stage 1 and stage 2 so quickly that they did half of the amount of work actually required for those stages. So then you're appointed for stage 3 and 4, and now you have to do additional work to actually get information that the previous architects didn't. So it's a terrible cycle that is also perpetuated by institutions that are supposed to follow the rules. So I feel that in that way they should also be held accountable, because essentially our industry is affected by the economy. So often you'll find people taking whatever work that they can, whether it's at a reduced price or at risk. That is my 2 cents.
Thanks, Adriana. That is not a 2 cent. You have raised some very, very valid points from your few years in industry. As you say, I think that part where you are saying that you would be taking over a project from another professional who maybe had done stage 1 or 2, and you come to realize that that stage 2 was still lacking. Now that's where, Adriana, you are taking on more risk that you shouldn't. And you are allowed to negotiate fees for those exclusions that the other professional has done. And there's no shame in that. In making a report, I've done that a couple of times, where I write this long list about what is still outstanding. I mean, it's factual. Remember, it's coming from you as an architectural profession. No. So you are registered. So what is written there, if you say there are no windows here, it means the fact. Adriana has said. And it means that if you are going to be taking over this work, the client has to remunerate according to this list, or you have to then start the work from the beginning and be remunerated from the beginning. Or I can imagine what some of the mature people in this panel will probably say to you, Adriana, they'll just say, walk away. Walk away. It's too early in your profession to be trying to take on so much risks. If you can participate on projects where you will get paid for what you have asked for at this point. But I appreciate your points. I have noted them down here, particularly this one about government and wanting to do insisting that we give percentages, discounts off on our work. It never used to be like that. Government used to pay you 100% of what your fees are, and these are some of the things that we are trying to fight. Even with the Engineering Council, we're trying to take them to Department of Public Works to make a stop at this, because it's just not sustainable. They have the money. That's what I think it is. Yes.
Is that it's difficult when it's not yourself working for yourself, but often it's a company that you apply for and you're employed by. So you sort of see keeping on taking on this work. And I think for the sake of the relationship with the government or the local authority, they keep taking on these projects, or they accept whatever rules come with it. But you're always held on a leash of often being expected to do more than what you're appointed for. and then being asked to do that work regardless while the PO is being sorted out internally. And often they would come back and not want to pay that additional fee, and then you've already done the work. So it's difficult when it's not me making the decisions in the company, and
Yeah.
obviously I want to stay employed. So
Okay. Yes. No, I understand. I understand. And you are working somewhere and you are speaking for what you see. But also, these are the lessons that you are taking for the day that you go off on your own and you just decide, I'm not going to do this rubbish. This is just crazy. I'm not going to subject myself to this. So I'm glad you're observing that. Thanks, Adriana. The next hand on the screen here is that of Tiens Boyens. Tiens, yes,
Right,
let's
thank
hear
you so
from
much.
you.
Thank you so much for this opportunity, and thank you for the opportunity to speak to my learned colleagues. I've been in practice for 22 years, since 2002, and I've seen some horror stories happening on both sides of the fence. I have been head of built environment in the government as well, and have recently relaunched my own practice. I'm currently working from the Cape, and things are certainly different here. And I've been starting to see architects standing up for this, and I don't want to name his name, but he's a star architect here in Cape Town. And at a recent presentation of Scape, he had a huge presentation where he actually took on SAPOA, and where he said, and I'm paraphrasing, but he said he doesn't know where the notion comes from that buildings does not cost money. In the rest of the world, is accepted as a privilege and a huge responsibility by the developers. It's only in South Africa that we are marginalized in this way. And he's taken this presentation into the deepest, darkest chambers of SAPOA. And I have to ask, if SAPOA is one of our sister entities, like the engineering councils and even the building council for the BCE, where do the responsibility lie? Is it just a old gentleman's club for property developers, or can we also start rating property developers in SAPOA the way we rate architects in terms of the identification of work, where we qualify or pre-qualify developers in the way that they responsibly handle contracts? I think that's a possibility that we can explore and should explore, especially in light of the impetus that is gaining traction down here in the Cape. That being said, it's basically like the same version of avoiding bakkie builders on sites, where we have the NHBRC climbing in and having actually a very good effect on quality and so forth. It's now, it should be on a SAPOA to be registering all the developers, even the mom and pop developers, where most of the difficulty starts, because people do not know how contracts work and the extent to which they are liable. So in that regard, what's good for the goose is good for the gander. If we are pre-qualified and we are professionally prescripted what to do and contract and try our very best to over-deliver on fast-track projects which are impossible, then I think SAPOA can meet us halfway and say, listen, for the sake of the industry and the quality that we require from our professionals in the field, we need to pre-qualify our developers in certain levels, the same as maybe the contractor levels in the CIDB is being done, where you've got a contractor grading, you must have a developer grading as well. And it should be sufficient for us then to only contract with these people. And I'd like to link onto what my learned colleague, what's his name, Atusei Msiska said as well, keeping control of the lien and keeping control of the city council process, and putting our authority down as master builders, as architects, and reclaiming our role in the profession. I think it's a question of us voicing our opinions and taking it to the man and speaking in these chambers of the old school ties. Thank you very much.
Well, thank you, Tunes. Well, if I'm just going to, I'm busy noting down all these. What you're saying is, look, I love what you're saying about your colleague and the fact that you're saying there in the Cape, a group of people are now starting to stand up against this rubbish activity that's been happening in our profession regarding free work, and that he's going and challenging some of these bodies. And I think if I were to just to highlight, SAPOA is not necessarily a sister council of SACEP. Our act tells us to recognize the allied professions, which are sitting there in our act, but they are a body that we would associate with. And I appreciate your comments, and that we couldn't be able to have conversations with them. But you know, Tians, I always feel that, you know, in our work, we should regulate where we can. We should control where we can. And when we have controlled our space and contracted it and signed it and locked it nicely, no one can try to penetrate there. Instead of going and having 1,000 meetings with people, and if that person is no longer the director in that company, then you need to go and repeat this again in another 4 years. So I always say, let's try and control where we can control in our space in order to stop the abuse. But I appreciate your comment, and I'm glad that you brought up that thing about SAPOA. Like, where did this come from? The fact that we can work for free. And when you touch on international, our registrar, he actually had to step away because he has a family bereavement to attend to. But he says that they've been doing some internal research, and they've come to realize that this whole risk work situation is happening mostly in our country, and it's hardly happening in international spaces. There people work. There people put their money. You have your little ideas and your little dreams, or your big dreams and your big ideas. You put money down. That's why their practices can grow. You have your Genslers that have 3,000 employees there. But that's because they're getting paid. I don't know where it's coming from here in South Africa. It was clearly created by some individuals many, many years ago, but now we are bearing the brunt, and it's even going and informing academia. So, folk, from the bit of desktop research we have realized, I've even tried to Google risk work. There is no such a thing. Work at risk. There's no such a thing. It only talks about architect managing your risk. So it just talks about when you are appointed within your workspace, what is the risks that you need to manage? So I think here we created a monster that we have baked in our country so much that it's even come and bite us. So thank you for that. And I am going to then ask Karabo Pitswe, and then thereafter we're going to have Lucas.
No problem. Thank you very much, colleagues. Is everybody hearing me?
Yes, Karabo.
All right, I can see my name there. Thank you very much. Look, I think one of the benefits of speaking nearing the end is that you get to hear multiple views from everybody, and it's amazing. Thank you very much for it. I'm very happy that the government representatives are also part of this as well, because it's not just a private sector thing. I just want to quickly touch on, because I do have a few points and I'll try and minimize as quickly as possible. With the public sector, you get RFPs that are sent out from certain state parastatals and all of that kind of stuff, kind of requesting discounts, requesting schemes, proposals, designs, with a loss of your copyright and all of those other things as well. That's what's happening in the public sector, which is literally what's happening in the private sector as well. All right. And in the private sector, you find yourself in a situation where the bigger businesses, because they've been doing work on risk for so long, and they can give such huge rebates. I mean, and I've been hearing of stories of 60%, 75% discounts. And obviously, SACAP, it can't attack any of them because the contract between any two parties is covered by law, blah, blah. So it's not a public thing. So you will find that there's already a bias towards you who comes in, because the client immediately says to you that, yeah, but if you won't do it, somebody else will take that rebate. Then you're forced, because now you're a small business, you're trying to grow, you're trying to expand, you get absorbed and sucked into something that has created a monopoly. And this is where the Competition Commission obviously has to come in, because as one of our colleagues said earlier on, was exactly that. It's anti-competitive behavior that just can't be proved. And without it being proven, the industry suffers as a whole. And then as it suffers, the smaller guys remain small, they take on more risk, and there are more PI claims, and even in PI, they lose. It's a lot of stuff. And the bigger guys, when you look at it all, they can afford to, because it's kind of modeled into their business model. Once you get to a certain point, you can have candidate architects, candidate senior technologists, or anybody else who they're not going to charge you a lot for them doing the work if you've just sketched out a concept versus you doing it yourself. Versus a small company, obviously the director finds themselves as the one who's actually working. So it's those kind of three things I wanted to look at. I understand that the public sector says that we pay you full gazette, but with all of the corruption as well in our industry, it's very seldom you get anything close to what is invoiced to anybody at that point. And you find yourself subcontracting majority of the time, as was mentioned prior as well, where professionals who are not even architects are receiving architectural work, and then you need to subcontract under that. So that was the one point about it all. The next point, you will find that, and I speak about the point of within business schools and real estate schools, they are taught in a certain way, and that's true. I've studied a second degree as well for real estate, and it's not necessarily really against us. It's a mandatory thing, and they know how to reduce risk on their side. So why speak on both sides as an architect and a developer? And it just makes sense for them to spend absolutely nothing till they are safe and guaranteed that this thing is going forward. They've already got their cap rates in, their profits. They know who to adjust, who to squeeze before they can press anybody for anything. But then you at that point, because you're so desperate for the work, you will just work on and hand them as much as you can. The issue always comes in that someone else is willing to do it. So therefore, for you, it's a take it or leave it. So hence why legalizing it in some kind of a framework helps. Now, I heard a few colleagues say that in every single thing that you do, there's risk. Yeah, look, it's the general kind of understanding of business as a whole. Like being an entrepreneur, there's a certain amount of risk and you have to take, yeah. But the key thing about it all is that, are you taking a risk when the client has already signed your client architect agreement? No, because when you go to site, you know you're going to be remunerated. When you're doing a risk, it's honestly you just saying, guys, if you take me, you take me. If you don't, you don't. You lose everything, the intellectual property and everything else. Discounts as well is the same issue, which is a huge risk. And last point I want to touch on as well is this. We used to have an IDOW as well internally, which would then assist with regards to which level or which standard internally we regulate ourselves. I know that a lot of our colleagues as well, oppose that. Competition Commission came into that as well. My question is that if we can't even agree within ourselves as an organization, as SACAP, how do we expect a developer or a client of any sort to have any kind of respect if they can see opportunities and gaps within what we represent as a whole? So thanks. I think long story short, and I'm speaking from the relatively young business, less than 10 years, who is on the public sector side and the private sector side, with many old colleagues who have a certain model of accepting discounts and evergreen contracts versus in the private sector where it's a take it or leave it. Thank you.
Thank you, Karabo. I have placed down your notes about you also enforce the fact that there should be some type of a framework in order to help on this risk work. You know, Karabo, I've heard other colleagues, it's usually the more mature colleagues, but then I've also been around. I've been an architect I've been in full-time work for about 16 years. I've been an architect for 12 years. So I'm of the mind that if you do not want to work with me the way that I need you to work with me, then it's fine. Then we're not of the same and it's okay. And then I just let you go. And then because I do believe that there's something else bigger in the horizon for me, and usually there is, and it is much, much more. So that thing of if you don't do it, somebody else will. I think there needs to come a time, and I hope that there'll come a time where professionals are able to also just stand up for themselves and each other by saying that, oh no, my friend, you said Karabo's not going to do it. What makes you think that I'm going to pick it up? No, sorry, Mrs. Developer, you can keep walking. All right then, but thanks for that point. President, would you like to say something? Or Ms. Mandisa, or any of my other council members that could be possibly attending today? If you'd like to share an experience. Yes, we'll have President and then
after first, if possible.
Okay. President, should I give
Yes,
there
please
was a
do.
yes, it sounds like it was Councillor Jennifer. Yes.
Yeah.
Is it Dr. Jen?
Thank you so much, President and Vice President, for one of the best CPDs of the year. Colleagues, I just want to share a few things. I'm mainly focused on the government part. Of course, I've had a lot of the comments about government, this and that, but VP, let me summarize this. Government works on paperwork, right? You need to have your paperwork in order. Paperwork, your contract.
Paperwork.
Yes. You must have been very clear on your paperwork. You cannot take a gamble on that. So whatever you submit to government at tender, you need to stick with that. Secondly, you must have understood the tender. If the tender said this is 1 month's work to do ABC, that's it. So after 1 month, you cannot turn around and say, oh, we didn't complete the work. Unfortunately, government doesn't work like that. Then the second part of it, VP, let me just summarize this one as well. The extensive discussion, I think Adriana indicated to the platform, VP, that is a contract issue. It's not even government. That is a contract issue. There you can see that the contract part between the firm and government was not paid, like the firm didn't look at word for word, what were they contracting with for government. Sadly, I think Karabo mentioned the part about government requesting the architecture firms to give up their rights. Look, governmental work can take up to 10 years, just a project. If you take housing and you put in the infrastructure and you put in all that, it can take up to 10 years. So it's become a rock and a hard place. So if we say that, okay, you cannot give up your rights as the architect with copyright on the drawing, what you're saying is when your term expires after 1 year, then government must go back to stage one. And then also that architect, it expires, then the government must go round and round stage one. And so it's kind of, VP, an issue between a rock and a hard place. So that's why government requests architectural firms to really surrender their copyrights on drawings, because that drawing is not going to be built in a month. If you've got a tender for 1,000 houses, that's going to take at least 5 years. So when your own contract expires, another architect is going to have to take over. Now, it's not that they're taking over your work, but they are taking over the next phase of the project. Now, that's where it becomes dicey or slippery, VP. But what we need to understand as professionals is that a project that takes over 10 years, there's no way government is going to employ just one architectural firm for over 10 years. In summary, last one, architects have the power to stop a tender, VP. If you can prove that the tender that's going out is purely architectural work and a consultant, engineer has been appointed, the architects have power to stop a tender. You can do it through SACAP, you can do it through SAIA, or you can do it as an architectural firm. You have the power to stop a tender. It happens, it doesn't happen all the time, but I just want architects to receive comfort that government is a very fair employer. Government is very aware of liquidation. So in effort to minimize the amount of money spent in liquidation between consultants and government, we are very crisp with paperwork. Thank you so much, Chair. I'll leave it at that.
Okay, that's my colleague, Ms. Jennifer, Dr. Jennifer. She is also a council member on SACAP, and she's a director at Human Settlements here in Pretoria. So she's speaking from that position. So you heard for yourselves that we do have the power to stop the tenders. In fact, I would say then we should stop all of them. And they must take the tender part off, and they must just give them back to all of us in any case. I like that. But also what then I would then ask is that why should then, if government is going to be taking 10 years, why can't they carry on 10 years with that particular architect on that one project? Because now they're playing us against each other. By me starting from stage 1, stage 2, and then I'm off after 2 years, and then another one comes in, and then another one comes in, another one comes in. Why are they asking that we must surrender the copyright? You don't hear an owner of a patent just surrendering it to government. These are some of these double standards that I think we need to be fighting against, or you just say you're not going to engage in that type of business. Karabo, I don't know if your hand is up because you want to respond to
yes. I
Councillor
just want to
Jen.
just
Yes.
we actually
Okay.
move on. So I
Yes.
understand about mass rollout projects. If it's RDPs where government has used templates forever, and on those ones you can't actually give copyrights because somebody has relinquished that a long time ago. I'm talking about, because speaking specifically to this seminar, the requests for proposals. And like I said, I don't want to name the parastatals in particular, but you get those who say that give us a scheme, this, that, and the other, you need to partner with a developer and all of that kind of stuff. So if the government is telling you that whatever you submit to us, we are going to keep, and it belongs to us at this point, how do we then attack when you see a building that you submitted on RFP being built by somebody else because it does not belong to you anymore? So hence why I am trying to speak to it here. And I'm trying to say that even the bids that go out asking us to relinquish our copyrights from the public sector are part of the problem. Not the repeat work of schools, museums, the templates they've got of everything. We understand that because it does take huge rollouts. And if you say human settlements, it makes sense. We understand why you would hand out a template for it. It takes many years for it. But these are the ones where there's a plot and they say, give us a scheme. Government is part of the problem at that point.
Okay, well, I think there, Mr. Karabo, that's where, as a practitioner, you do have a choice to just walk away and say you're not going to be a part of this type of thing. I think we tend to forget how much power that we have within ourselves, although some of that power make you feel that you're going to have to eat toast and bread for a little bit, but then it always feels better. You know, there's an element of, at least you know that your values, your pure core values are not being made to bend. And then we're gonna have this hand of Cornelius, and then thereafter I'm also gonna just check with I don't know if Councillor Mandisa, you want to say something, or President Ndugu. So in the meantime, let's have Cornelius, and then I'm gonna also go into the chat box. There's some comments there. Cornelius.
Good afternoon. Can you hear me?
Yes, Cornelius, I can hear you.
Okay, my issue is I've been in the building industry since 1980. So it's a long time. I've been in all sectors, you know, and with plans, designs, all that. I've built myself. I've also been a regulator, inspector for a long period, senior, and all that. So my knowledge is from all the sides. Now, what I want to say is all these discussions, it's valuable, it's advice, you know, and everything. But what bothers me and the most challenging thing is SACAP is a legislated body. In other words, it's by law and you must register. But you see, local authorities are not the same. Some instances you get a certain treatment with your plan submitted, and the others is other way and all that. And then there is also like the NHBRC and all, many different regulators. I've listened to many discussions, and even with SAIA, like they said, you know, architecture in the past, the architect was the main person who handle and treat a project. Now it's coming get away, and the reason I see it very clearly, and I've tried to discuss this with many people for some time. You see, I believe the only proper way to handle the building component is actually we have to have intercommunication. Town councils, there should be a you know, for instance, say for instance you have a municipality cannot issue a occupation certificate unless Form 4, and you know we have so many powerful tools in SANS, all this, where Form 4 stipulate this is the appointed architect. They may not issue occupation certificate before NHBRC signed off, before the architect signed Form 4.
Yes.
But now, you know, you might be the architect, you see the people occupy the house, they've got an occupation. You were never asked. So therefore, there should be much better intercommunication between all these bodies. You get like NHBRC, architects doesn't have a barcode, only EXA. And EXA should be included in this, all this. I mean, you should have EXA, town council, all that, and it should be interlocking. You, all of them should be able to check a project. So you know, so if the client changed the architect, if he didn't have submit the form where this previous or initial person signed off and say, I'm quitting, he must be the person to sign. And if he doesn't sign, you don't get your occupation. You can demand your money outstanding. It will be much easier and there will be much better control. But the problem is everybody, all the bodies runs their own way. For instance, now every house with NHBRC, because the architect, there is certain scopes he can design himself according to SANS. Now you design a house like that, but you still need the engineer to come and sign. On the end is the engineer must sign the soil classification and he takes responsibility. So the architect is never called to that. How can they expect the town council now expect you to sign Form 4? And then furthermore, I mean, the NHBRC approved, it's occupied, and the town council issue, you don't have control, but should there be a trouble on that house, they're going to ask who's the architect.
Absolutely.
So you see the empowerment and the application of all these things. That, I say, is the biggest issue. There's so lot I can talk about this because I've got a lot of experience. Unfortunately, nobody wants to listen to this, but I think if we have all this in reality, I mean, take for instance the George building situation. You should have been able to go on your computer, see this is the architect, this was the engineer, this is, you know, then if a question is asked, SAPA can show their power and say, this is where our responsibilities is. Or this. But now, I mean, it's running around. It's going to take a year or two to finalize something. And like I said to them, there is not only one person involved there. There's a lot of regulators. There's a lot of things in. I mean, building are being built and houses, double stories. How do we know the Occupation and Health Safety Act has been applied? And actually, the architect is responsible. So now, all of a sudden, the architect profession is the lower one. It's no longer anybody jump into this project and they take over and nothing is said. So all these nice things, I appreciate that. I do not say it's wrong. I just say the implementation is very important. And, you know, the cooperation between all these should be one platform for the building industry, not 20 different bodies having a finger in the pie. Without taking consideration the other parties.
Yes. Mr. Cornelius, I think first we can appreciate your years of experience from 1980. That is huge. I think I was 1 then. And you are saying something very pertinent. I think the current air that is happening is that all of these councils and disciplines have moved away from being the allied professions. They were called the allied professions for a reason when the act was enacted in 2000. And that was for the fact that these fingers come together and then like a key and they close this whole circle that, you know, the client cannot maneuver without the other. You know, because in this day and age, if you are contracted from stage 1 to stage 6, you find that to some extent you have good control. You know, life is good and it's very romantic with the client up until maybe the end of stage 2. That is if you're 4.2, if the municipality also did approve your plans nicely. And then thereafter, the client just somehow they disappear. They just disappear into oblivion. And then if you are to follow up, you find that, oh no, we decided to just carry on and we're going to build it ourselves. And now you have the stage 5 that you're contracted to, and you got to find a way to go and get your money, get your money back. And that's what you're talking about. The fact that a building can also be
not only that.
Yes,
I mean, because everything is carrying on. You have the local authority, they don't respect the SACAP power. They
so what
occupation.
Yes, what SACAP is doing and what we're working on some stuff internally. Can't necessarily talk about it as yet because it's still work in progress. It's in a way to be able to help enforce when it comes to building plan submission. And also in enforcing that the right person is the one that is submitting these building plans. I mean, my dream would be the day that plans are only submitted and approved by architects or the extensions of their offices and then that's enough. I mean, architectural professionals, and that would be a piece of registered architectural professionals. The day a client has to be asked, do you confirm that your registered, your design professional is indeed a registered architectural professional? And then they say yes. And then there's many things that also that fall from that roll out from that. So
you see, and then like, sorry to interrupt, but
Yes,
I
sir.
mean, I've
Okay.
spoken to head office in HPRSP. We have been in the discussion November last year. And I spoke about this. What is the competent person in certain sizes of houses and whatever? The architect can be himself. Now you load costs by enforcing the employment of an engineer. Why isn't the architect also issued with a barcode? He can sign the forms and he takes responsibility. And then also, you know, there's some power the architect will have on his project. He refused to sign forms if the client went outside the scope of agreement.
Yes.
And I
Okay,
don't
Mr.
hear anything
Cornelius.
of it further.
Yeah. No, Mr. Cornelius, I think we're going off the very important topic of the day. And it's not to say the things that you are not saying are not pertinent. But I think we need to drive towards back to what we've been talking about. Because all of these points that have been coming through about risk work are really about getting paid. And all of these points are going to be informing our professional fees committee. So we need to continue to get them out of the colleagues. Are there any hands, Mr. Munetsi? Are there any other hands? I'm just looking for commentary in the chat box.
No, it's only okay. There are only two new ones. Let's give the two new ones only. Yeah.
Okay, I don't see them, but you can name them so they can speak.
Okay. It's Galaxy Note 8.
Yes.
And
Galaxy.
William and Tsepo.
And William
So
Lowe.
they are, yeah, yes, those three.
Okay, Galaxy, can you kindly state your name and then your name first? Galaxy Note 8. Okay.
Yeah. Afternoon, Chair. Sorry, I probably should have put my name to it. And now I'm just a gadget, but there is a whole human behind here. But sorry for that.
Okay.
My name is Wisdom, and I'm a practicing person, just like my colleagues before me, and I've been doing that for a while now. I do share a lot in terms of experiences of both on the ups and the downside of things, but just a couple of things that seems to point to the whole issue of work at risk. In my own experience, I've tried it on 2 or 3 incidences where it was like something of a table value nature, and what came through was that I challenged the developer to simply say, can you state your risk on this project? I'll state my risks that you're asking me to work at risk. So I will state my risk, but can you be able to put yours on the table? And that became a very difficult conversation. Not difficult for me, but the developers most of the times could never really tell me what they were risking. Either the land wasn't theirs, either it was very speculative. They had put in no money of their own. They just had about no risk at all. And I think maybe even as we contemplate the idea of actually finding the way of regularizing this, or kind of accepting it as a potential way of working, but I think there's a need to speak to more of these risks, shared risks, well, even if it's not shared, but each party's risks and be quantified as a way of agreeing to even attempt to consider such kind of work. If the party that is carrying more risks, in terms of potential loss of income, what about your PI cover on something which can come and bite you and you've made no money for it? So I've found it that I think the developers bring nothing to the table. Now we've even dived deeper into the whole area of they want a very controlled percentage of fee. Somehow they've come up with a 2%. of certain costs. They exclude that cost, that cost, and it's a 2% flat. They can take you for 5 years for 2%. And so it's a space where we kind of losing control, but I think we've contributed to it as a body of professionals. I really do believe we've allowed this thing to really run wildfire amongst us. But I think the layers behind it are also people who are not the real people doing the actual work in the background.
Yes.
I mean, like Cornelius, Mr. Kutsia and others who are in the Cape, they can share with me. I go around some of the sites, you will not see a single detail of who is behind it, what the professional team is. There's a lot of work going on. But I mean, for people who take pride in creating, these pieces of art and beautiful stuff, you should really be able to be showcasing it of who you are. Much of it only speaks to the fact that there is a lot of shenanigans and really dealing behind much of the work that is going on. And I think we somehow in there we are guilty parties to this space.
Yes.
That's really my couple of cents worth of contribution. Sorry, I am a human being. Sorry, my galaxy. Yeah.
It's okay. It's okay. I just think that if you had adjusted your name, it will help later when you need to claim CPD, because we'll be using this list. So I think you should change your name very quickly. No, I appreciate what you have said, and the fact that what is their risk, while you know what your risk is, and that there's nothing on the table. And for the fact that as you're speaking now, we now are seeing that on these developer boards, in fact, that's what we now call it. It's no longer the architect's board, it's the developer's board, and the architectural name is not there. The company name is no longer there. It's just this developer board, this pomp developer that is bringing this new development. But who are the people who've been part of this project? They're no longer there. I'm just trying to see if there's another question. Good afternoon from Tiu. Tiu says, good afternoon. My point is, how can a professional mitigate the risk of a tender process that requires a design proposal? Usually, this is a result of a design and build tender or competitive design tender. Yeah. That's I think maybe Councillor Vusi or Dr. Jen, maybe that's where you can help answer. How can a professional mitigate the risk in a tender process that requires a design proposal? I think the risk I'm trying to see the risk that could be there is that you've created this design thing and then you don't get the work, and then maybe that design gets given over to the one who gets to win the work. I've often been very suspicious of such. Can you answer there, Jennifer?
Thank you so much, Vice President, and thanks to the question on the call. Two things, VP. The first thing is that when architectural professionals see a tender, they need to read the blueprints. Number one. Number two is that once a tender goes out, there's a tender briefing. You need to ask, what does design proposal mean? Are you talking about stage 1 to 6? Are you talking about stage 1? I mean, you need to ask those questions and you need to get it back in writing. You can't even argue that the tender is not clear enough and it needs to be redrafted, because design proposal, that's huge. You need to ask the government department to break it down for you. Then at the tender briefing, if you don't get answers, you need to ask the department to put it in writing. What do they mean by that? Now, if it's competitive, then that's competitive. Again, you need to ask for clarity. What happens after the competition? Are we doing a competition? And then after that, whoever wins, that project will be taken forth. But Vice President and colleagues, one thing about government will pay you. There's no tender that goes out unpaid. That is for sure. Even if it's a proposal to design door locks on RDP houses, you will get paid. That's one thing you should be. By the way, I'm not affiliated to any political party. Just let's get that out of the way. Chair, you will get paid. Over to you, Councillor Vusi.
You don't need to mention politics. I didn't hear anything that's political. Anyway, go on. Yes, Councillor Musi, you can
Yeah.
speak. Yes.
Thank you, VP. I'm not familiar with any practice or trend where architects are being hired by government departments and not paid for work done.
I think this.
Rabo mentioned there's RFQs required. Obviously, once you are appointed, you are given an appointment letter, which has other addendums like your appointment clauses, which spells out how you are about how you should be claiming. You know, the tariff of fees, disbursements, traveling.
Thank you so much for joining us.
Yeah, so all those terms would be spelled out in that appointment letter. Unless you aren't appointed, then
And you
as
get
a
free delivery for orders
professional,
over 1,000 Rand. And of course, there's so many.
okay.
Yes.
As a professional, you are assuming the risk. You're assuming the risk that you will do the work and not be remunerated for it. But I'm not familiar with that trend where government appointments are not honored. There's another issue raised by Karabo relating to discounted fees.
Yes.
There's a serious problem there with discounted fees, and this results in, you know, poor quality, poor output from RPs, because now they cannot do the work for the work, for the amounts that they've tendered for. And hence we are saying we've created this webinar so that we can educate each other and, you know, agree collectively on trends that we feel or are of the view that should be regulated, or you know, SACEP should have inputs or put mechanisms in place to deal with such. Yeah, that's my own view. VP, thank you.
Yes,
VP, just one more thing. Sorry, I forgot one. If that's okay with you.
Yes, go on.
Colleagues and Vice President, the other thing I'd like us as the architecture profession to know is that there's a difference between an official asking you for work and government asking you for work. Those are two different people. It happens to us all the time. I mean, as officials, you could be asked, listen, we need your section to give us ideas on the latest building designs for state housing. So guess what? I pick up the phone, I call Prez, I say, hey, Prez, can you please give me the latest designs 2024 for architecture that the Department of Human Settlements can take over? You see, that is not a paid piece of work. It's coming from me. Now, that's different from a piece of work that is advertised and says the Department of Human Settlements is looking for consultants in the architecture profession to give ideas on the building design. VP and colleagues, those are two different things. So I think as colleagues, we also need to pay attention to where is this work coming from? Because officials don't pay. It is government who pays through a tender system, through an appointment system. Thank you so much, Chairperson.
Yeah, no, that's fine. I think what the colleagues are saying is that when you ask to submit a tender and the brief says they need some high level type of, they call it high level. In fact, that's the word they use for some type of a design, sketch plan, whatnot have you. That's what they're saying. And then the fear is now you do all this, you don't get the work. And of course, that means you're not going to get remunerated for that time. There was another hand here. We have a hand from Kelvin, as well as there was a hand from Tepo Limawana. So we'll take Tepo first. He had his hand first before yourself, Kevin. So I think please keep your hand up, Kevin, that way I see it. Tepo, I would like you to speak. Tepo Limawana. You had your hand, and I'd like to know what you were going to say before you took it down. Tsepo? Okay, Tsepo is not saying anything here. Jock is saying, before we go to Kevin, Jock is saying, in my early days, when I'd done some private work in my contract, I used to have that when the plans are approved by the council, final payments need to be done. No payment, no plans. I like what Jacques is also saying, because I think as professionals, architectural professionals, we tend to forget that these drawings are yours. And why are we handing over drawings when you haven't received all of your money? You know, as a practicing architect in my practice, in fact, I even go as far as I do not, from stage 1 right up until stage 4.2, that client comes to the office to look at the drawings or the design. At that stage 2, they sign it off in the office and they leave it, and then they go. So they go away with the dream sitting in their head. And then again in stage 3, they come again and then they sign off and then they go away with the dream sitting in their head. And when you come to think about it, you actually realize that you're claiming almost 70% of your fees and the client doesn't have even a smidgen of one of your drawings. So that's where we need to enforce where we can. Your work is still your commodity. And the only time that they get to see hard copies and they have them for the first time ever, they get to go away with them is when they've been approved and I've gotten my money back. I've gotten all my money. So that's what I do, because I feel that's the least that I can try to control. Kevin, I would like you to speak. Kevin else? Kevin. Okay, there are no hands. Are you seeing any hands there, Mr. Munetsi? Okay, here's comments from Tsepo Limawana. Tsepo has written us a nice love letter here as well in the Q&A. He says, good day. I think to mitigate payment risk in architectural work, professionals can implement the following strategies. 1, obtain written agreements with clients that clearly define payment schedules, terms, and conditions. I agree with that. And then 2, request deposits or progress payments throughout the project to minimize the amount of work owed at the end of the project. I love that point as well, and I also agree with it. 3, negotiate payment terms that align with the completion of deliverables or milestones on the project. I love that too. Monitor project cash flow and invoice regularly to ensure that the clients are aware of outstanding balances. Invoicing regularly is very important, because your invoice is a legal note. When it's sent out, it means something is due. Enforce payment deadlines and pursue legal remedies when necessary to collect payments. Now, Tsepo, you've said a lot. You've said a lot, and it's very pertinent, the things you've said. Before I take your hand, Manus, I will say that the attorney that I live with, Mr. Shongwe, when I ask him about these things, he says to me, but Mashongwe, where do you get this thing about risk work? And I'm like, well, it's there. It's there in our profession. He says, I've been doing research. I don't see anything about this risk work. There's no such a contract on it. What is this thing that you on about? I said, we're all doing it. We are all stressed about it. And he would always say, but it all goes down to an agreement. It all goes down to contracts and the agreement there. So, Mr. Manus, you can speak. Manus, you have your hand up. Thank you, Tsepo. Thank you for your very helpful comments. Manus?
Madam VP, yes, thank you very much.
Yes.
I would just like to raise an issue in conclusion from my side. After having listened to all the comments and read all the comments in the comment box. I think a lot of what is being said, the guidelines and the laws already exist for example, Rule 4.1 of the Code of Conduct, how fees should be set out, how it should be agreed upon, etc. So it's very important that professionals take note and cognizance of the contents of the Code of Conduct Rule 4.1 specifically, obviously the rest of it as well. Just in conclusion from my side, what I've learned is that people treat us the way we allow them to treat us. Personally, from a personal perspective, I believe that doing risk work diminishes our professional standing. My practice undertakes work globally, which includes for foreign governments. And as you know, I'm currently sitting in my office in Warsaw, Poland, and risk work is a very foreign concept outside of the South African boundaries. Unfortunately, architects today have to undertake work on risk because of expectations created by professionals willing to part with their own hard-earned resources to subsidize already wealthy clients. It makes no business sense to me, personally. If a developer doesn't have money to pay your fees from the get-go, it should already raise a red flag, and one should already be very skeptical at that point. Clients that need a professional to loan them money effectively to get a project off the ground should A, raise a serious flag, and B, if the professional does agree, should pay interest to the professional as they would to any bank. But getting a development loan from a bank, as we know, is not as easy as getting an unofficial, no strings attached loan from a registered person. Meeting a client on site to discuss a possible project is not the same as doing any architectural work. The risks there are negligible and absorbable. Just finally, budgets vary and are adjusted from work stage to work stage, and budgets can be established during stage 1 already. And an initial fee can be calculated in line with our knowledge of certain building typologies. Ultimately, I feel risk work can be avoided and need not be entertained if professionals form a united front and take a strong business stance that if the client wants our product, we as professionals need to be paid from the beginning of rendered services, as with any other product. If not, unfortunately, the profession will never become lucrative for the majority of professionals. And for one professional to simply walk away from risk work is also not a solution. So we propose that a democratic process should be followed, and the question of risk work should perhaps be put to the vote via a survey from SACAP to obtain a clearer understanding of its place within the architectural profession, and based on that, perhaps set up a committee with representatives from both sides of the coin to address this issue. And I, for one, would be more than willing to participate in that. Thank you. That's from me.
Okay. Manus, thank you so much for your comment. I like what you said when you're talking about suggesting that maybe there should be a vote with a survey, maybe that says those that are 100% for risk work, some for controlled risk, and some who are entirely against it. And then let's see what that yields. But besides that, in any case, my good colleagues, I just want to summarize a little bit the points that have come through. One of the points is to create some type of specific standard terms in order to de-risk, meaning to take away some risks. We had comment from one of the colleagues that says, what about equity, having some type of equity on the land, meaning you have the ability to have a hold on the land. We talk about also limiting the risk, also creating this type of a framework for feasibility work. There was also points here about having in stage 1, having another stage 1.1 or 1.5 or stage 1.5, meaning a feasibility type of stage before you even go into stage 2. Or maybe another one is to be able to control the risk up until the end of stage 2. Manus, what you were saying, that thing of going out to site and have a discussion and meeting with the client of the land to take the brief, that is very nominal risk. In fact, that's doing business. You know, you got to go and see about the people before you are engaging with the people. There was also some other comments here. So by and large, from what I see, yes, I like this one that says that we need to also create type of a register where if you are engaged in normal standard work and with the normal stages, you go and list your work accordingly, like that with SACAP, where there's also a list that says, no, this work is pro bono, so that it is known to everyone that no, this one is free because it's for charity, and the architect decided that they're going to do it, and it's for free and it's for charity, and that's what it is. So that one is a different expectation. But what I keep taking out from all our discussions is that somewhere in all of this, we have forgotten that we have a right to what is good for us and what we want, and that can only be placed in a contract. You know, there's the client architect agreement by SACAP. There is the shorter version by SACAP. There is a SIAT client architect agreement. There's a SIA client architect agreement. And what I've also come to learn is that the more descriptive a contract is, the better. And architectural professionals, they tend to think that, no, I don't need this clause. I don't need this. This is too cumbersome. This is too much for the client. The client's going to get overwhelmed. Well, what I can tell you is that you need all these clauses, because at the end, when the relationship is no longer sitting in a good place, you're gonna wish and desire that you had actually included all these clauses. And at the end of the day, I feel that if somebody does not respect you enough to sign your agreement, then they're not wanting to work with you. They're not seeing you as being valuable. And I can tell you that as chairperson of professional fees, which I enjoy a lot when it comes to matters of money, because we've got to look after that, we are going to be taking all of these lists and the minutes that are going to come from the secretariat, and they're going to go back into the committee, and we're going to see how we can affect some of the clauses and the government gazette, other VAs, and see what we can come up in creating documentation that will enable our professionals to work in a more safer space. Or maybe we can just decide that we're just going to do away with all of it entirely, and people need to pay. So we need to stop the idea of abuse, and we need to take a stand. Like Manus says, I don't do any free work. I'm not going to do that. I'd rather put my feet up. Yeah. So my good colleague says the hand that has come up here, I can't see who this hand is from. Is it Manus again? There's a hand here. Is that your old hand? President, Manus, were you wanting to say
No,
something?
apologies, Madam VP, I've lowered my hand.
Okay, that is fine. I would have liked the advocate to speak, but I can tell you in the energy that he would be saying to you, look, guys, we're going to take back all of these items, and we're going to see what we can do in as far as law and what law allows us to do in our regulatory body. But he is going to say, and as Ms. Bessie, I would like you to also speak after this regarding the value and the importance of contracts. Contracts are everything. Contracts are everything. Ms. Bessie, I'd like you to speak, and then we'll have President to sign off. Ms. Bessie, I'd like you to speak with regards to the value of contracting and also getting attorneys to contract for you. So don't create your own clauses there. Ms. Bessie?
Thank you, Madam Chair, much appreciated. And also just to appreciate everyone who is still in attendance and all the contributions that we have received today. And just to state, as you have stated already, that we will be considering everything that has been tabled. We will look to it and obviously revert back to the professionals. From my side, before I even enter into the contracting, Some points that I also just want to stress is just to remind registered professionals that also at SACEP we are here, are available to assist you whenever you come across situations where you may need some advice. And also just to stress on the application of Rule 3.4, I hear a lot of people are referring to their architectural work being used by other professionals. This rule is there to protect you as the professional. Therefore, if you have such a situation, please bring it forth to SACEP as well. We are looking into such matters, and we have had cases where we have looked into such issues, and we were able to apply the provisions of the Code of Conduct against the architect that is taking on another professional's work. And then also just to stress, there was comments that were received in relation to the issue of unregistered persons still rendering work out there. We just want to please again ask you that when you come across such, take the time and let us know, drop an email and let us know this is what you have noticed, and then we will look into it. We will try to gather as much evidence as we can, even where you may not have enough evidence, because these people are working in social media, these people are working in places and advertising their services, and we do have an SAPS official who is able to go into such places everywhere in the country, looking into such conduct and actually opening SAPS cases against such persons. So if there is a municipality that's also still allowing such, you just let us know and we will do our best. And then also to come on to the contractual issue, SACEP is trying to protect professionals by having Rule 4.1. Rule 4.1 is very important. I think a lot of people think Rule 4.1 is only there to protect the client maybe, or look at it in a negative manner, but it's actually a rule that seeks to protect you as the professional. As it was stressed in my presentation, that the Rule 4.1 does require that before you do anything, you reduce it into writing, and legally for work that you have rendered, you are supposed to be paid for such work. And again, just to stress on what Madam Chair has stressed, that it should be part of your preliminary work for your company or your practice, that you do obtain legal advice to ensure that you are protected when you are rendering services. I've heard a lot of people, or somebody mentioned that, the clients are so reluctant when it comes to Rule 4.1. They're willing to pay up front, for example. You might find yourself accepting such, but you will find that when something goes wrong, the clients will definitely come to SACEP and they will definitely state that there was a verbal agreement in place, no matter what the conditions were at the commencement of the agreement. Therefore, it's much advisable that you always have something in writing to protect yourself as well, and also obviously to protect yourself against risk work. And then also just to state that from our side, what I also note and will also propose is that when we do presentations on either the Code of Professional Conduct or any other issue that SACEP is working on, because we don't only talk to architectural professionals, we also are exposed to members of the public, we should try to mention this issue just to try and raise awareness, so that even the people that are hiring professionals also are aware that this is an issue, and also aware that obviously that the terms of Rule 4.1 are applicable. And also we will also be presenting to other professionals who may not be here today when we do such presentations, so that they are aware that Rule 4.1 is compulsory and should be complied with. And I am hoping that everybody in attendance here, after hearing the issues and how it has negatively impacted other professionals, they also will be taking that into consideration in future when they are accepting work or when they are proposed to do certain work. But I really appreciate the time. I really appreciate as well being able to be part of this impactful event. Thank you so much, Madam Chair, and committee members, as well as to the panel members here.
Yeah, thank you, Ms. Bessie. Thank you for your input and the contribution that you do at SACEP, even though you sit on the disciplinary committee, but here you are, you're also trying to educate us on a better way. If I can just give some a bit of teaching points. One of the things that can keep you out of falling in trouble with SACEP is just to ensure that your letterhead has everything that is needed. This is part of the code of conduct. If you can just look at that, that's a very important point. President, I think I'm going to give it to you to to wrap up there for us. But all I can say is, my good colleagues, it is your human right to charge. You know, the universe and the gods and the God, our gods, they all say that you have to charge in order for you to thrive. It's given to us. We just need to take it, and you need to put those numbers down, the numbers that you feel I need to be remunerated this much in order for me to be able to do this work. And I believe that we're placed here to thrive on this earth. So we also need to take courage and walk away from certain practices and just walk away and say, no, then we cannot be friends. You are not for me. You don't want to pay me. You want to come here with a car that looks like it can start flying, but you don't want to pay me. Then we are not of the same. I'm not of those values. Thank you so much for this awesome afternoon. I'm excited about this topic. It pinches me as well. I have a practice. I don't want to have to encounter funny things. I know we're going to attend to this. President, please talk to the folks. And then it was lovely. Those are my last words. Thanks.
Thank you, VP. Thank you, Chair. Thank you for sharing such a sensitive topic. And it is a problem. It will continue to be a problem, but I think at least we've discussed a lot of mitigating factors that we can put in place to reduce the risk. I think the profession has spoken. A lot of contribution as far as exercising Leanne on your work. You know, I think for me, those are good suggestions that we need to take into consideration, that you know, we have to take it seriously, that when we are embarking on a service and then we expect payment, and I think the rules and the regulations and the way we contract are set out, you know, right at the beginning, so that if anything happens, there is a clear recourse to you as a professional. What is going to happen? I would love to exercise a lien on part of the project if really I'm owed something, you know, it doesn't come at the right time, then I'm entitled to the ownership and actually dispose that part of the project so that I can get my money back. So yeah, these are sensible participations and contributions from the profession, and I think we take this seriously. And you know, it is a problem, and it is a problem that we have to solve it ourselves. And I think what is very important, I know we haven't spent a lot of time on this issue. We put too much emphasis on the contract, that please enter into a clear contract with the client. But as well, it is as good as the rule 4.3 that as a professional, when another professional has worked on a particular project, to not take over that project without finding out how has that professional been terminated, has he been paid for, has been paid for what he or she has done, and then you alert that professional. So it is part of the code of conduct, and I think we can amplify these rules to actually be specific on the risk work and to actually get more mitigating factors so that our profession becomes sustainable for the future. And it is us who can solve this problem. We cannot expect people outside this profession to solve our own problems. I think in those words, I really want to thank the profession, everyone who participated. And then this is the kind of, you know, like talks that we need to have as a profession, so that we put our heads together to trash out our problems, and then we move forward. And SACEP is here. If you want us to regulate, to put more or meat or teeth in our regulation to make sure that we do not suffer as a profession, definitely will do that. I'm looking forward to a situation where you cannot contract with the government if your tax compliance is not up to date. So if we can step up to that level as a profession, that the clients must not contract with us if they are not compliant on their side, and we are not compliant on our side. I think that is the direction that we need to take. Certain things must come automatically. I heard some of the contributions where the ARPs were saying, I mean, when you submit, drawings for approval, I mean, it must maybe become a prerequisite that that submission goes with the contract itself. The municipality must not accept that, without the contract in place. I think I'm looking forward to those days when we make easy for our professionals, because sometimes we bogged down with the issues of design because we're passionate about architecture, but we forget the business side where we get shortchanged, and then we are not happy, and then we look and cry foul. And I think we need to always be vigilant and make sure that we set the record. We have everything on black and white. But I think I'm happy with the direction that we're taking, and I think with this conversation, it does not stop here. Feel free to contact SACEP, send email to register anyone, myself, to better our standing as a profession. I think we're not here we are here to protect professionals as well. Not only clients, I mean public. Without the professionals, the clients won't be serviced. We need to strike the balance. With those words, I really want to thank all of you for participation. Thank you, Manas, for taking up this issue head on, whether we are happy or not happy. But I think the conversation has already been started, and I think there will be an end, a conclusion, a nice conclusion, and an improvement in this area of our work where we minimize and mitigate the risk. Thank you very much, colleagues. It's Friday. It's 2 o'clock by now. I declare the meeting, the webinar closed. Thank you very much for participation. You will get a feedback definitely from your participation. Thank you.
Thank you, Pres. Thank you, you fine folk.